till the next date of listing.
Obliged.
And did you?
Please, your lordship.
Also, third, yes.
Please, your lordship. Item number 40.
40.
40. My
Yes.
humble prayer is if it can be upgraded as per convenience of your lordship.
But today there is a
at
difficulty.
two.
Today, from the
Before
bar,
rising, my lord, before
we'll be
rising.
sitting till 2 o'clock. We'll not have a break. After 2, we'll not be able to. So break we'll have it at 12 o'clock. Thereafter,
If it is possible, my lord, before rising.
I think it will come.
Obliged.
Item number 43 of today's order,
Hmm.
daily cause list. So this matter, my lord, there is a matter also pending before the learned trial court.
Yes.
I pray, my lord, this matter may kindly be listed after 12th of May, my lord. So that is the date before the learned trial court.
Okay. You are
Lordship,
for
sir,
the Bank of India.
I am for Bank of India, my lord. Only a date may be
None has
fixed.
appeared for the other side.
No, my lord, the service is not complete.
Okay. Sri A. Ganguly, Senate Counsel for the petitioner submits that a connected matter is pending consideration before the civil court, the date of which is fixed on 12th.
12/5.
12/5. 12/5.
12/5.
He according 12/5/2023. He accordingly prays for adjourning this matter to a date thereafter. Please this case in the
Can a date be fixed?
in the third week of May.
Can a date be fixed? The surface I matter.
You are seeking an adjournment to 2 months and you are asking for a date.
Only because the matter is pending before the learned.
So what? Do it
Alright,
today
All right, my lord, I'll mention.
on third week of May. This is 43. Is there an interim order?
No interim.
Third week of May.
Lordship, public.
Okay.
It is a lordship. Lordship, this is regarding that CMJ-ED matter.
Yes, yes.
My lord, as per my lord's convenience, if the date after BU may be
Supplement
fixed.
study क्यों नहीं है? Good night, do. Yes,
My lord, today the matter is not listed.
Yes,
my
yes.
lord, but my lord has directed on the other day to have a.
you all mentioned before court number 4.
My lord, but
For listing purposes, not before this
so,
court.
my lord has said to ask for a date with my lord's convenience also that day. So we have come before my lords. I'll take the mention memo over there and pass it to the court master.
We cannot grant any order. That's not a part heard matter. It's a different matter that we have heard it, but it's not a part, it's not tagged as part heard. It's all mentioned before that court. Yes, next.
Praise the Lordship. So item number 41 on behalf of Mr. PJ Pokon, I would like to mention this.
41.
These are out of
Yes.
station, Your Lordship. Function has been taken, Your Lordship. 41.
You're on behalf of Mr. PJ Fukan.
Yes, Your Lordship.
When do you want?
On 5th or 4th.
You have filed the affidavit.
No, therefore. No, Lordship.
You filed the affidavit? No.
No,
You'll be filing the affidavit or not?
Did I have to ask you?
No, this is a contempt matter, isn't it?
Yes, Your Lordship.
On a prayer made on behalf of the PJ Fukan, Learned Counsel for the respondents. List after
On 4th, Your Lordship. On 4th April or 5th.
4th April, just 2-3 days will be difficult. Okay, on
Then-
4th of April, let's see. Yes.
May I please, your lordship, I beg to mention item number 27 of the daily list, lordship. This matter may kindly be adjourned for the day, lordship.
Okay.
Interim may be continued.
On a prayer made on behalf of Sri TJ Mahanta Learned Senior Counsel, matters then adjourned by 2 weeks. Interim order passed earlier to continue till the next date of listing.
Obliged, lordship.
May it please, my lord. May I pray for a listing of a matter in the coming week, my lord?
Court
My lord,
number 4.
My lord.
Court number 4. Mention in court number 4.
My lord.
May I please, Lord? Lordship, I beg to mention item number 35, my lord. This matter may be listed on 10 April, my lord. Service is awaited, my lord.
Item number 30.
35, my lord.
Contempt matter.
Content matter.
When do you want?
10, my lord.
Why fixed date in the contempt matter?
Yes, sir.
A prayer for adjournment has been made on behalf of the petitioner. A list after 2 weeks. Yes.
Date may be fixed, my lord.
Contempt matter, we are fixing date. Do it today. What is the urgency of fixing a date in a contempt?
Actually, in spite of the court.
We
order, my
understand.
lord,
What is the urgency?
I
He'll
am-
go to jail. That is the urgency.
Lordship, I am not allowed to perform my duties.
So
my
what
lord,
is
in
what
spite
is
of-
the consequence of a contempt matter? What is the relief you will get? One will be penalized. This is not an executing court. For that, is there any urgency? Yes,
I'd like to mention item one, Lordship.
yes.
With the instruction, I would like to withdraw this.
Your name is not there.
My name is Lordship.
Item
Mr.
number?
Lenzo, item number one,
Your name is not there in the cause list.
Mr. Lenzo.
Have you seen the cause list?
Yes.
Have you signed the wakalat number or not?
Yes, Lord.
You are Mr. A. Sharma.
Mr. Lenzo, Lord.
You are with Mr. A. Sharma.
Yes, Lord.
How do you spell your name? Please give it to him. So and so learned counsel for the petitioner submits that there is instructions to withdraw this writ petition. Full stop.
Liberty may be granted.
Instruction to withdraw this with however at liberty. Full stop. Agriculture. Anyone?
May I please, Lord?
You are the item number one, Mr. Chaudhary. Sri B. Chaudhary. Then Standing Council Agriculture Department is present. Para. Writ petition is accordingly dismissed on withdrawal with liberty as prayed for.
Like.
Yes.
May I please, Lordship, respondent number 11, 12, 13, 14 have filed a affidavit today.
Where, which matter?
Which matter that I don't know, Lordship.
No, you have to know the matter, which item
Item for item number 7, sorry, my Lordship.
you want to get it in with the records.
Yes, my Lordship.
Also will
Different
kindly see the order dated 4/11/2022 also. The tank in question, the artificial tanks were created
Item
by
number?
two laws.
Yes, yes.
Artificial tanks were created by the Fishery Development Corporation. These are not registered fisheries. And thereafter, Lordship, tank has been allocated to us to give fees by own contribution and to give the revenue. We have paid the revenue for 3 years. Thereafter, they have cancelled the order. We are not objecting to cancel.
Your allotment has been cancelled.
Cancelled. We are not for that, Lordship.
Hmm.
We had prayed on last occasion in court on at the time of motion hearing that we should be allowed to remove the fees which we have given in the pond in question. But this is not a natural fishery. This is a pond created by the Fishery Development Corporation for fees cultivation. We have given the fees at our own cost as per agreement. And we have also paid the fees, everything we have invested. We have also given the Lordship revenue also for 3 years. That is cancelled. We have modified the prayer that we do not want to continue with the settlement order. We want to remove the fees. And on last occasion, on 4/11/2022, instruction was directed to obtain.
Hmm.
Accordingly, this court has recorded the statement that they will allow to remove the fees which we have breathed in the pond in question.
Hmm.
Thereafter, they have to file an affidavit. Lordship, whether affidavit will be filed or whether we will be allowed to remove the fees. Our fees, we have breathed, we have our own investment.
Have you filed the affidavit? No.
So Lordship, there is a change in the decision, Lordship. There is at that time, at that point of time, there was an instruction, Lordship. They were about to decide, Lordship. They are about to file affidavit.
Then? Now what is your stand now?
Then is Lordship, no, at that time only verbal instruction was there, Lordship. So written instruction is that we are at this point of time, Lordship, the pond in question, the fees which were there in the pond, we don't know who they are saying that they are part, Lordship. It is not determined at all. So we cannot extract, we cannot allow them to extract it,
Lordship, this is not an artificial.
That is our now we are thinking that this way, Lordship, even in the earlier while.
Is there any claim by any other party?
No.
No. While no.
If there is no claim by any other party, it is an admitted fact that they were allotted the fishery, the pond.
Lordship.
They have cancelled it, they have not challenged. They want to take out the fish which they have reared. Now, if you have a difficulty, you have to
Yes,
tell
we
us.
have to, we will.
Now, what is the difficulty? Difficulty has to be a reasonable difficulty.
Lordship.
That your money is involved, some third party right has been created.
that part will be examined. I will file
No, why,
that.
where is the scope of examination? Prima facie.
Prima facie, lordship, with the pawn, they have, as per them, they,
It's a pond created artificially
lordship,
to breed fish. Now they have given,
lordship,
they have reared the fish,
lordship, that is.
cancelled.
Lordship.
The allotment order itself.
Lordship, regarding,
And once the instruction was that they'll be allowed to remove the fish, it'll be for a particular period. They cannot keep on removing. Maybe a week's time.
Your lordship, in fact, let me give it in a written, by way of written affidavit, lordship.
That was given to you in November
Lordship,
2022.
give me one,
We are in March.
give me 2 weeks time, lordship, I will give it,
A week's time, only 1 week.
lordship,
Only 1 week.
lordship.
Heard Sri S.K. Goswami, Learned
But
Counsel
I'm-
for the petitioner.
there is an IA, my lord.
I for
IA
I for
for
implement, they have filed an application implement that fishery is question is not given any tender process. That is why they want to implement. They are not in the picture. They want that it should be settled by tender process. We have no objection to that, but they are not in this
they are
kind
not even questioning the cancellation of allotment.
No, my lord, what my submission is that, my lord, there were 18 fisheries, my lord, total, 18 ponds, my lord. The petitioner, he was granted lease for 3 ponds, my lord, as per his own work order. In the prayer made in the petition, he said that pond number 1 to 6.
No, we are not praying for that.
Let me finish. I am aggrieved by the fact that this honorable court passed an order. Your lordship will find 21/10/2022. It is provided that till the next returnable date, the respondents in the AFDC shall not act upon the ponds in question in any manner, including extracting of fishes therefrom. My lord, it includes all the ponds, my lord. If your lordships kindly turn to the writ petition for a
We'll
moment,
clarify that.
because they
We'll
ultimately.
clarify that, Mr. Das.
Yes,
That
lordship.
is there.
If that is clarified and they issued, and because I approached the authorities that you issued an NIT because I was allotted pond number 6. You issue NIT.
But so far as the fishing aspect is
I
concerned,
have nothing to say
No.
with regard to pond number 1, 2, and 3.
1, 2, and 3, they'll not go ahead because once third party right is,
Other they can move, go ahead, Miller. With the tender process.
you were added in 3 ponds.
3 ponds.
Heard Sri S.K. Goswami, Learned Counsel for the petitioner, also heard Sri P. Sharma, Learned Standing Counsel, AFDC. Sri H.K. Das, Learned Counsel, has appeared for the applicant who has filed IA Civil 754/2023 for implement of party respondent. Full stop. Para. It is the case of the petitioner that he was, that it's a committee, that the petitioner committee was allotted 3 ponds created by the AFDC for the purpose of breeding and rearing fish. Full stop. However, the state allotment was cancelled. Which by an order dated 26/4/2022, which order also includes 3 other ponds.
No, there were total 18 ponds, my lord, in that order, page 49.
No, cancellation is 6 ponds.
6 ponds.
Cancellation order is 6 ponds.
Not 6 I can do.
Cancellation is not for 18. Allotment, we are not on 18. We are on the cancellation, which includes
18, my lord.
Cancellation is 1 to 6.
1 to 6 only.
Yes, ma'am.
1 to 6.
6 ponds. Full stop.
No, here we have cancelled all 18.
No,
ponds,
no,
lord.
it will be because we have not on the
Page 20, page
That is not on the
20.
26/4/22.
Page 28 is influence.
26/4/22.
Yes, ma'am.
How many ponds cancelled?
18.
18 ponds.
And they are the in question here is only 1 to 6.
Now, why are you
1 to
challenging
3.
6 ponds? You are given 3 ponds.
Lordship, we have given the 6 ponds. Now, after that, Lordship, we have allotted only 3 ponds. We have specifically stated we have allotted only 3 ponds.
Or
And as per the allotment order, we have to give all investment, everything. We have to give revenue.
No, we have not.
if your
understood.
lordships kindly come to page
No.
28, my lord.
You are given 3 or 6.
3.
But why 6 you have paid
6 has
for?
been allotted, but 3 has been given position.
There is nothing on, as per our record, found. There is
No, when the statement is made by him, we'll make it clear.
In fact,
No,
allotment
that will
orders
say-
itself says that they were given 3 points, my lord. In
Yes.
allotment order says,
Okay,
my lord. Because they will consider the subsequent 3 points in the next year.
Okay,
And
okay,
next year
okay,
that was allotted to others.
Oh, no, क्या लिखा है allotment?
1 to
Oh, which order none lage? Order is so and so. The Sri Goswami clarifies that though the initial allotment to the petitioner was for 6 pounds, comma, only 3 pounds were given possession thereof, and the subject and the writ petition pertains to
only 3.
those 3 pounds. Full stop. He has further submitted on instructions that though the initial challenge was against the cancellation of allotment, comma, he would be satisfied if the petitioner is allowed to extract the fishes which has been reared in the period from which the petitioner was given the possession. Full stop. The learned counsel further submits that
কিন্তু তো আপনার আছে।
in the present proceeding, comma,
411.
an order, there is an order dated 4/11/2022 of this court, wherein the statement of the learned counsel for the AFDC has been recorded, that a decision has been arrived at to allow the petitioner to remove the fishes over the pond over which the petitioner claims legal right. This court had directed that an affidavit be filed incorporating the said statement. Full stop. However, comma, till date, no such affidavit has been filed. Neither such affidavit has been filed, nor the petitioners have been allowed to extract the fishes. Full stop. Tara. 3. Sharma, the learned standing counsel AFDC, however, submits that there is a change in the perception of the corporation, and there seems to be a review of the decision which was conveyed to this court as recorded in the order dated 4/11/2022. Full stop. The aforesaid submission made, apart from being contrary to the earlier concession made, does not appear to be reasonable, inasmuch as it is not the case of the department that there has been any claim by any third party or any third party right has accrued in the meantime, and it is not in dispute that it is the petitioner society which has reared the fishes in question. Full stop. Para. 3. H.K. Sharma, H.K. Das, counsel for the applicant who seeks implement, submits that the purpose of the applicant to be implemented is to bring to the notice of this court is that in the prayer portion, comma, of in the prayer, comma, the writ petitioner has prayed for, has sought relief for 6 number of ponds, whereas only 3 numbers of ponds have actually been given possession of. Full stop. He further submits that there should not be any restriction so far as allotment of the ponds which are not the subject matter of this writ petition. Full stop. He said prayer of Sri Das appears to be reasonable and in fact is not objected to by Sri Goswami, the learned counsel for the petitioner. Full stop. Therefore, instead of passing any effective orders in IA Civil 754/223, this court directs that the embargo imposed by this court will be restricted to only 3 ponds. Namely, there are names,
No,
Only one from
1 to
January.
3 ponds, that's
Phone
serial
number
numbers,
one, two,
Only one is
to and
there,
three.
only one.
that's
is there.
serial numbers 1, 2, and 3.
Oh, no, two is not there, Lordship.
1,
Only one.
1 to 3.
Can two is Krishnamani Das.
No, 1, 2, and 3. Itu নহয়, itu order নহয়. Allotment order to chua.
It cancellation order. too.
Cancellation order নহয়, order page 28.
may I come in, Madam? Page 29, it says Gorjan, Bulujan, bill tank within bracket, tank number 1, 2, and 3, my
1,
lord.
2, and 3.
Paper is there. my lord.
1, 2, and 3.
One.
1, 2, and 3. Full stop. In the meantime, this week, this court further grants a week's time to the Learned Standing Council, AFDC, to file an affidavit with regard to the statement made allowing the petitioner to extract the fishes from the pond in question.
They can move ahead with also for the other ponds, my lord.
That's a no embargo.
Lordship,
My lord.
there is some discrepancies in the record, Lordship. I in the 49, Lordship. Page number 49, in the order, cancellation order, Lordship, in 3 and 4, there is another name is also stated. Page number 49, Lordship.
You tell us, we'll go by your thing.
Lordship, that is.
There are
why-
three ponds in position.
Page 29.
We'll clarify the affidavit, Lordship.
No, don't go ahead with those ponds which are given position. You will be knowing better.
Lordship.
We are having the restrictions only for 3 ponds in question,
Which they are in
which were
position.
given in position.
Lordship.
Others, you are
Lordship,
free
in the
to go
meantime,
ahead.
we are proceeding for tender, Lordship. Embargo.
We have already said. Last में क्या बोला?
Tender.
They may proceed if your lordships add, that will not help.
Why should we advise them?
Even
We
then,
said
my
there is
lord.
no.
Near
no
no
embargo.
embargo. Lordship has said no embargo. Well, that is
क्या
absolutely
बोलना?
fine.
ना उससे पहले. Yes.
Applies.
Fix a date. Let the matter be listed on on 10th, on 11th.
May I say one thing, Lordship, for clarity, Lordship, embargo, it is not restricted to any tender, Lordship, that may be.
If you do not understand English, we can't help.
Lordship.
Applies.
Highly obliged.
I may seek your lordship indulgence.
Yes.
My lord, item 9, the additional advocate general is out of station on Monday. I've informed the other side.
Yes.
Wednesday, if this honorable court directs,
Wednesday will be, I think, is it to open? Yes, Wednesday will be difficult. 5th,
6th, 7th,
5th onwards, we'll have the function in the second half. Second half will not be sitting.
then 10th, my lord, subject to the convenience.
10th is there, Mr. Bhuya.
That I
What about
get-
Tuesday?
Tuesday, my lord, he's going to be back. Both the advocate general and the additional advocate general, they are not
On
in
10th.
station.
10th.
Obliged.
Sponsor. 10th. First. Huh? 2 का तो दे दिया मैंने. 2 का कौन सा बोला? 2 10th ही बोला. और ये भी 10th. और जो मेंशन किया था. कौन सा 20? कौन सा मेंशन टू? 9. 10th. Yes. Yes,
Your
madam.
lordship. These are lordship unfortunate people who are victim of land erosion lordship.
Hmm.
In the year 2011-12, they settled in under Hajar Revenue Circle lordship. Recently, an eviction process has initiated against them. They have some of them received lordship, but since all of them are under same revenue circle, it is expected that all of them will be. My humble prayer before your lordship with that, some rehabilitation may be done for us, lordship, because we are the victim of, land erosion of IT Brahmaputra, lordship. That part may be considered.
Where was your original land?
Then it was lordship, different parts.
Have you stated the description
No,
of your
I have not.
original land?
I have not.
What is your right? Who are you?
Here,
You said that you are erosion affected.
Lordship, I have in annex some certificates also.
Certificates will not do. Where were your original land? What was the DAG number, patta number?
That much I will take instruction. All of
What
them.
is this? This is the basic thing you have not pleaded. What instructions are to be taken here?
But in every erosion certificate, Lordship, the lands
We are not bothered even with the erosion certificate.
no, lands are described from where we are.
Let us see.
It's not described. Let's
Let us
see,
see.
my
Let us see.
page 16, my lord.
No, let us see. We will see.
Lordship, page number 16.
Yes.
So resident of Larkuchi under Poschim Borkhetri More.
Yes.
No.
Which
That number,
is
patta
the
number.
land?
Tag number, patta number is
So
not.
that
there,
is
but
important. This is a vague thing. Of 2012. Under what consideration this is issued? We have doubts.
Erosion of 1988, my lord.
No, if from that erosion has taken place, Lordship, regular.
And in 2012, he gives a certificate.
Yes.
On what basis? Yes, the
That's-
circle officer. Ask him, what
Yes,
basis? On what records?
16.
And what is the description of the land you had? You were owners possessing land. Or I must ask Kanungo, learned counsel for the petitioners who claim to be victims of land erosion by the Brahmaputra River. Full stop. It is the claim of the petitioners that they are residing on over land at the Kin Singra village of Hajo Revenue Circle, falling under covered by DAG number, not falling under, covered by DAG number 286. Full stop. However, based on a case for eviction, notices have been issued in connection with eviction case number 14/2022-23. Full stop. The petitioners are aggrieved by the said eviction process and accordingly has filed the present writ petition. The petitioners have also prayed for alternative arrangement for their livelihood. Full stop. In support of their claim, certain certificates of the year 2012 have been annexed, issued by the circle officer, which states that the petitioner
Second floor, 89.
is a landless person due to erosion in the year 1988. Full stop. Apart from the fact that apart from the issue as to whether in 2012 it can be certified that a person was eroded, had become a victim of land erosion in the year 1988, no documents worth its name to connect the petitioners with any land of which they were title holders have been even mentioned or annexed. Full stop. The learned counsel for the petitioner prays for and is granted 2 weeks' time to file such documents by means of an additional affidavit. List after 2 weeks, along with such affidavit, additional affidavit for motion.
Please, Your Lordship.
Yes.
I tender my apology, Your Lordship. We have communicated with DFO. DFO is in midst of a while elephant census. So by Monday, we'll pass the speaking order, Your Lordship. We just need time till Monday, Your Lordship. It's assured by Monday.
Then Monday, if you pass, when will you
We'll
get
bring
the,
out record by Tuesday. Let me take it up Tuesday.
on Tuesday?
Yes, Tuesday. Your
My
Lordship.
lord, everything is going out of my hand.
Google R or Google Understanding Council Forest Department submits that that some more time may be granted. Some accommodation may be granted to the for full compliance of the earlier direction, requiring the DFO to consider the representation by a speaking order. Full stop para. On the other hand, urgency has been expressed by Sri Mahanta, Senate Council for the petition of full stop para. Considering the same, list for motion on 4th
Your Lordship. We'll bring it on record.
4th April.
Tuesday.
Tuesday.
My lord,
Tuesday.
is it possible, my lord, on the next day of the Monday, my lord, Tuesday, my lord?
Tuesday only.
Tuesday.
Tuesday, 4th. Next day.
Because, my lord, already 50% vegetables already lost, my lord, because of this raining, my lord. Everything is gone, my lord.
Bring
Sure.
it. Next.
Obliged.
The matter may be passed over for time.
What is the matter about?
On
Madam?
payment of contractor's bill, Lordship. Earlier, he approached a court, Lordship order is there.
Why pass over? You do it. What is the
And
problem?
work order is 93, 96.
The amount is admitted by the chief engineer, Lordship.
93 matter.
Work order is 93. Work
But if
order
I kindly turn to page 33, Lordship, when it's paid. It has been it is admitted by the chief engineer. There are many communication between the department. The partner is a physically disabled person.
What about the earlier?
Earlier order is Lordship page
Page
36.
37.
No, you have withdrawn.
We have withdrawn and we approached the department, Lordship, and the representation is page 38, Lordship. No action.
There is an acknowledgement of the chief engineer
Yes.
here.
Absolutely.
But you are correct in contending that the worker of 1996.
2002. The communications starts from
But road is-
Annexure 4, Lordship.
road is-
Your name? Your
H.
name?
Agarwal. H. Agarwal.
Heard 3H Agarwal Learned Counsel for the petitioner, who by means of this petition has prayed for a direction for release of contractual bills. Full stop. Full stop. Though it appears that the works are of the year are almost are almost two decades old, and a few of the works, this acknowledgement was for which work?
Hmm.
It's all for all the works.
This is the consolidated amount.
Lordship.
There is an acknowledgement of liability by a communication issued by the additional chief engineer,
One page.
PWD roads, dated 4/1/2017. This total amount is 5 lakhs.
Yes, Lordship. What more?
Oh,
The petitioner is a physically disabled person, Lord.
of क्या बोला? Full stop. Para. Issue notice of motion returnable by 4 weeks. MSS Sharma, learned sending concept PWD, accept notice on behalf of respond numbers 1,
1, 3,
1, 3, 4,
4,
5,
5, 7,
7,
and 8.
and 8. MS Finance, MVR. Learned counsel accepts notice on behalf of respond number 2. Right?
Yes, sir.
Madam,
11.
6 is revenue.
Presented by.
Or revenue department represented by deputy commissioner. What is this?
Not a necessary.
Okay, for the time being, revenue department is there. A button surgery. Telling council revenue department for response number 6. Let extra copies
Yes.
be served upon the learned council for the respondents by tomorrow or by Monday. Okay, what is this kind of airing of parties number 6? Have you seen? Revenue department through the district commissioner. What is the district commissioner? You apply your mind, don't file a petitions like this. District commissioner means what? Yes. Next. 4 weeks now. Madam, you take instructions regarding the acknowledgement.
Yes.
We have some doubts.
Yes.
Item number?
7. Comes of your lord, or order of your lordship. They filed a private respondents, they filed an affidavit today itself. But I have got a copy right now. It requires some time to go through it.
Is a habitual harasser.
That is what this want to say. I have to confront my client. I have to confront my client in that.
So it's good for you. Yes, what is your instruction?
Just now I have received, my lord. One messenger has come.
If you have received just now, this what has this received in this moment.
My lord, I apologize for that because.
You don't
Sent-
need time to read this. 2 minutes is sufficient. At least you
That reiteration,
will have an idea.
yes, my lord, that reiteration on the petitioner's version is there, my lord. That registering of miscase and all these things is there, my lord, but records,
He has not expressed any opinion.
opinion, my
He
lord.
just stated the facts.
The facts are there.
On
according to
the circuit officer on the official count found to be meritless and has dropped the case.
Yes.
that whatever is stated in writ petition is reiterated.
So what we are concerned is that what would be the outcome if we restore?
No, the outcome maybe I may at best otherwise also die after going.
No. Suppose we give you the relief. We give you the relief, we interfere with the order, we remand it back for fresh adjudication. And the matter is adjudicated by the circle officer. They think that the land which you propose to buy is an incumbent land.
Yes.
Then you'll not buy, you're only proposing to buy the land.
That's good.
If you are having grave doubt on the land, why are you filing cases?
Yes.
You should not, do not buy the land.
Therefore, my lord, I require some time after going through the affidavit of this.
No, we find the lack of bonafide in this petition.
My lord.
Can it be posted on 10th, my lord? So I have another matter.
See, you propose to buy a plot of land. You think that the plot of land is, there is some encumbrance.
Incumbent.
You make an inquiry, and in the inquiry, your case has been registered and that is dismissed.
Yes.
Till then, you are again not satisfied with the dismissal. That means you really think that land is encumbered. Do not buy the property.
No, one thing is that it has been rejected on the ground, on the ground which is not correct.
No, that is it.
Yes,
That is if we even if we interfere
Yes.
and remand it back,
And
and
supposing it is held,
hell, either way,
either way.
then also you are at liberty to buy, not to buy.
Let it be posted on 10th. I have another matter on 10th also.
I think you should advise your client.
Yes, yes, that is what I
A
am.
senior person like you is there.
I am contributing that way.
Think over whether
Yes.
it should be pursued or not. Sri D. Das, Learned Counsel for the respondables,
11 to 14.
11 to 14, has filed an affidavit in opposition today by furnishing copies to the petitioner's counsel, full stop. MSM Borman, Learned State Counsel, has also produced the written instructions, full stop. Para, Sri B.C. Das, Learned Senior Counsel for the petitioner, prays for some time to obtain instructions on the affidavit in opposition filed, full stop. As paid for, list on 10th. 10-4.
10-4.
Yeah, please, Lordship.
Yes, please.
Petitioner's own my lord, he was my lord, he died my lord in police custody my lord. Lordship, the incident took place in the year 2012 my lord. Thereafter my lord, long process my lord has gone my lord. Petitioner my lord tried to prosecute the police officer my lord. So regarding this my lord, FIR is there and your lordship passed the judgment my lord. Lord, granting liberty to the petitioner to obtain prosecution sanction my lord. So, can I accept his lordship judgment, my lord? Accordingly, my lord, petitioner applied for a sanction, but ultimately it was denied, my lord. So, under this circumstance, my lord, petitioner is, my lord, seeking some compensation, my lord, ex gratia, my lord. Prosecution sanction is also denied, my lord. That is why, my
Ex gratia, if it is not a custodial killing,
Yes,
then
my lord.
where is the question of ex gratia?
And kindly peruse page 82, my lord.
police custodial death, my lord, and that is why, my lord.
Custodial death has not been prima facie approved.
Yes.
Even the sanction has been denied. Where is the question of ex gratia?
My lord, ex gratia, my lord, claimed, my lord, on the ground that he was under police custody, my lord.
Yes, what was the finding?
Lord, that is not.
What was the finding? Why the court has interfered? Why no sanction has not been granted? You challenge the order of not granting of sanction.
Yes, my lord.
My lord, that is, my lord, taking preparation, my lord. Petitioner will, my lord.
This we are not entertaining.
And on the basis of one notification is there, my lord, which has under the finance department, my lord, which is also based on the report of SP and other officials, my lord, regarding the firing incident. In this place, my lord, page 82, it's clearly stated on the basis of SP and other officials, my lord, that it's not a police firing, my lord. So to that extent, this report notification also does not cover his case, my lord. Though by this notification, power is being delegated to PC, my lord.
Your name?
Some time maybe.
Your name, your name.
Islam, my lord.
Huh?
Yes.
Mr. Islam, you can very well challenge 3rd of January 2023,
My lord.
by which the sanction has been refused. But until and unless it is on record that there is no custodial death, you cannot be granted ex gratia.
Yes.
You are an accused in a very serious case of dacoity and killing. Now, while
That is also not proved. That was allegation, my lord. The lawsuit is right, my lord.
that trial is on or not?
My lord,
What about the trial?
Lord,
Charges
Going
has been
concern.
submitted, my lord, on 26/10/2013, as per a report of this page
And
82.
on a very strange kind of incident, this had happened. One person, the driver was killed.
my lord.
His dead body was not found. This person was taken because he said that he'll locate the spot. The dead body was located. He took a weapon. He tried to fire. Then he was shot at.
My
And
lord,
the fact that the dead body of the driver was also located in the vicinity.
That is the version of the police officer, my
No,
lord.
thereafter the sanction has not been granted. You have not
Regarding that,
challenged
my
the
lord,
order
it
of
says,
not
my lord,
granting of sanction.
When magistral inquiry has also done, my lord, as per page
Some
82.
time will be given, my lord, regarding other.
No, where is Gracia? Where is the question of Gracia at this stage? Unless you make out a case in the appropriate forum that can be some element of custodial death, your allegation, there is nothing.
Some time may be given, my lord, for some more preparation, my lord, regarding this, my lord.
Heard through J. Islam, learned counsel for the petitioner, who by means of this petition is praying for a direction for payment of ex gratia due to the within inverted comma custodial death of the son of the petitioner. Full stop. It is projected in the petitioner that on 3/6/2012, the son of the petitioner, Jahangir Alam, was arrested by the police along with 4 other persons on the allegation of stealing a white Ford car by killing the driver. Full stop. It is alleged that the Sheikh Jahangir Alam was assaulted and was killed by shooting under handcuffed condition. Full stop. It is the case of the petitioner that a complaint case dated, our complaint case being CR case number 528/2012 was lodged against the concerned sub-inspector on 1/12/2012 before the learned court of the Chief Judicial Magistrate Borpeta. Full stop. However, the proceedings was quashed by this court by order dated 26/3/2021 in criminal petition number 607/2016. However, in the said decision, liberty was granted to the petitioner to obtain prosecution section as required under section 197 of the CRPC. Full stop. The application for such prosecution sanction has been declined by an order dated 3/1/2023. Full stop. Thereafter, the present petition has been filed. Full stop. Also heard M. Borman, Learned State Council. Full stop. FSI, when the very allegation of custodial deaths has not been established and the sanction and the permission for prosecution sanction has been declined by an order dated 3/1/2023, the question of any direction for making ex gratia payment of an accused involved in a serious case of murder and dacoity cannot be granted. Full stop. It also appears that though the incident was of 3/6/2012, in which Borpeta PS case number 739/2012 under section 482, 302, 120 within brackets capital B, public 224, public 34 IPC was registered against the accused persons involved in the said murder and dacoity, comma, the complaint case was registered after about 6 months, which itself raises a lot of doubt and suspicion on the bona fide of the on the part of the petitioner. For the para, be that as it may, comma, the learned counsel for the petitioner at this stage pays for some time to obtain instruction. For the para, list on when
2 weeks, my lord.
list after 2 weeks.
Knowledge.
Please, your lordship. On the last occasion, they directed to produce the instruction.
Yes, pharmacist license.
Lordship, the instructions are still awaited in this case.
Get it, get it.
Yes, Lordship.
How much more time?
Lordship, it may be listed after bifurcations. We'll try our best to get our instructions.
We'll have a date then. Sri M. Bhuya, appearing for the Health and Family Welfare Department, submits that instructions are still awaited. Full stop. He accordingly prays for and is granted time for obtaining the same para as agreed to by the parties. List on on that will be on 21st. 21st.
Deeply obliged, your
Much
lordship.
obliged, Lordship.
If the case was fixed for instruction, I have received instruction. The department has received the appeal of the petitioner. It is under process. But within a very short period, he will be intimated about the personal hearing.
Okay, Lord.
We record this and we close
Yes,
this.
Lordship.
Heard MSM Bhattacharjee.
Then till date, Lordship, nothing, no coercive action, Lordship. I'm praying for this only.
There is the prerogative of the appellate authority, Lords. Lords, nothing will be
Because
happening.
it's not acted upon the appeal till 7 months.
Now we'll
Lordship.
say till the appeal is
Yes,
till the appeal is disposed of.
Yeah.
But then it will again create problem, Lordship. It will.
Till the appeal is disposed of, matter is at your hand.
Yes.
No, Lordship.
It will not look good. You are also adjudicating, you are also taking action.
No, Lordship. Once it is admitted.
Will give liberty to her to file an application, you considered it. Heard MSM Bhattacharjee, learned counsel for the petitioner who is aggrieved by a demand come show cause notice.
Lordship, after demand comes, show cause notice, there are order in original, Lordship. which
No,
was passed.
let us dictate the order. Demand come issued by the central GST. There were earlier rounds of litigations and with directions for reconsideration. Whereafter, an order dated 31/5/2022 was passed by confirming the demand for the period 2014-15 to 2017-18 with another amount as penalty, correct? Against this order, comma, the petitioner has preferred an appeal under section 85 of the Finance Act 1994, which according to the petitioner was not attended to. Full stop, para. This court wide order dated 24/3/2023 had directed Sri S.C. Kyle, learned standing counsel, central GST, to obtain instructions. Full stop, para. Sri Kyle, a learned standing counsel, CGST, submits that instructions have been received, as per which the appellate authority is looking into the matter, and very soon a date for personal hearing of the petitioner would be given. Full stop. Para. MSM Bhattacharya, the learned counsel for the petitioner submits that if say that since the grievance of the petitioner has been substantially redressed by consideration of the appeal, comma, there may not be any live cause of action to be adjudicated. Full stop. See, however, only submits that till adjudication of the appeal, comma, no coercive action be taken. Full stop. Para. After hearing the parties and consideration and considering the submissions made, comma, since it appears that the appeal has been taken into board, in which the petitioner would also be given personal hearing, comma, this court is of the opinion that no further adjudication, that this writ petition may not call for any further cause of, any further adjudication. Full stop. Accordingly, full stop. However, comma, regarding the apprehension of the petitioner regarding coercive action, comma, while this petition is being closed, comma, liberty is given to the petitioner to file an application praying for such relief of not to take coercive action till the disposal of the appeal, and in the event such application is filed, comma, the same may be considered by passing a speaking order.
Lordship, 1 minute. We already have filed the appeal because this is our statutory remedy that
Not
we
the
sought.
appeal, not the appeal.
Lordship.
Application for stay.
Understood, Lordship, because they have not given us any receipt. So we were standing nowhere, Lordship.
No,
Because
see,
except the copy of the appeal, we have nothing because their acknowledgement is also not there, Lordship.
We have
This is what
recorded
I
his
said.
statement. We can have a date also for your appearance if you say. We have recorded his
And
statement.
if Lordship, then kindly Lordship direct them to within a very limited period, they dispose of the appeal, Lordship.
That we cannot say. We'll say that
Because it's already 7 months.
the appellate authority is however directed to immediately issue a notice indicating the date of hearing
Please, Lordship.
within a period of 1 week from today.
Lordship.
Make 2 weeks. Because
No, we issue it within 1 week.
Issuing
We are
notice.
not here asking you to have the hearing within 1 week.
Yes, Lordship. Deeply obliged, your Lordship.
You'll have the certified copy today itself, don't worry. Yes.
Lordship, I have filed this petition because the designated officer of the Food and Safety Department has not acted on my complaint as per the provision of the Food and Safety Standard Act 2006. The fact of the case is that, Lordship, I have purchased a drinking water jar of 20 liters. And after that, I found some foreign particles inside the jar. Thereafter, I made a complaint to the food and business operator of the manufacturer in terms of the provision is contained in section 40 of the Act. And I also made a complaint to the designated officer, and it was sent to the laboratory, and it was confirmed that yes, it is not, there is some foreign particles in the water and which is not safe for public health. But when the report came to the designated officer, he refused to take action against the violating manufacturer on pretext that there is some procedural lacuna, which you will find is on the page number 38 of my last page of my petition. Lordship, I am just reading out the relevant portion. It is the second paragraph. The complaint submitted another petition on so and so to the Deputy Commissioner Kachar Silchar, on which noted by you for failure to take action pursuant to the findings of the analysis report, especially in terms of the section 40 of the FSS Act 2006. It is clearly mentioned on the rule 244 within bracket 2 and 3 of the FSS rules 2011 that purchaser may have the food articles analyzed by the food analyst according to the procedure as noticed in the writing form VB of his intention to the food business operator, and two sealed package will be taken as
Yes,
simple.
Madam, any instruction?
No, my lord, it had come for first time, my lord. Designated officer is represented by my friend. He is under the health department, but his name is not shown also.
You take instructions, we'll ask a copy to be given.
Lordship, the most important aspect of this case, they are making the act unenforceable on the procedural level. And if someone complains, they will have to act against the violating manufacturer. Only to protect the violating manufacturer. This report came in 1 year ago in the office of the designated officer. They kept hiding inside the file. When I approached the deputy commissioner, only then this report came out.
But essentially, don't you think that these are in the nature of tort, tortious liability?
As per the
These are
act,
matters where, yes, there's an act. Of course, we are not non-suiting you, but ultimately the question of evidence will come. One has to prove that there is some foreign.
there is proof by a report, analysis
whom?
report, by the state level food. State
No,
food
that is not
laboratory.
adjudicated. That is by an authority. That is not, there is no adjudication. You may take advantage of this report, which is in your favor. And of course, there is a statute, which of course will ask the council to have the instruction, what is the outcome or what actions they have taken.
Yes.
Heard. This is item number,
Item number 12, Lord.
Ali Reza Osmani. Heard Sri FZ Mazumdar, learned counsel for the petitioner, who is aggrieved by the inaction on the part of the authorities to act on a complaint made lodged by the petitioner involving the Food Safety Standard Act. Full stop. It is the case of the petitioner that he had detected some foreign particles in a jar, in a 20-liter jar of Bisleri mineral water, which was accordingly brought to the notice of the authorities. Full stop. By filing the aforesaid complaint. As per section 40 of the Act. Full stop. It is the case of the petitioner that the jar was sent to the food analyst for examination, and in the same examination a report was issued confirming the allegation of the petitioner. Full stop. However, the said report was kept in cold storage and not acted upon for almost a year. Full stop. Para. Issue notice returnable by 4 weeks. Food and Civil Supplies,
I'm appearing. my lord.
MSM Bourbon, State Council,
1 and 3, I am appearing, my lord.
1 and 3.
Two and
Then-
four, I'll be-
Hmm?
2 and 4, I'll be.
M. Bhuya, Senate Council accepts notice on behalf of Reservoirs 2 and 4. What about 5?
5 is a manufacturer.
Private respondent, okay.
Registered postman.
Let extra copies of the requisition be served upon the Senate Council for the respondents by Monday. That notice be served upon the respondent number 5 by registered post with AD, serves by Monday.
Lordship, if I get.
Penalty shall not be a bar to proceed further with the report of the analyst.
Lordship, if I get liberty, then I may take dusty service also in respect of the person.
So number 5, we would like to have Dusty, okay. 5 or last board. Additionally, as prayed for, the petitioner is at liberty to serve Dusty upon the respondent number 5. Full stop. Needless to state that such justice is required to be rooted to the registry of this court, and the notice accompanying the justice service is to reflect the next date fixed, which is the first on 28th of April. 28th of April. Prior to this next date, comma, the petitioner is required to file an affidavit in proof of such justice service. Okay.
SC health may be reflected.
The name of ST health may be reflected.
OSP is also directed to reflect SC health in the cause list.
Obliged.
Obliged.
Please, your lordship. My lord, here, my lord, on last occasion, lordship had questioned like whether it will be maintainable before this honorable court. Here, my lord, the section 43, subsection 5 requires deposit for filing up appeal. But my lord, if I may take your lordship to that provision, my lord, it will be applicable only to a promoter. Here is a case, my lord, where the petitioner before your lordship is no longer a promoter by virtue of the agreement, my lord. She had, her husband, who was a promoter, has transferred entire liability to the new promoter. And that new promoter has been also registered under RERA, and he has undertaken some construction. But he was not made a party in spite of the fact being brought before the RERA.
And why are you aggrieved?
Because now the liability has been fixed on me by
If the liability and mass has been taken by the new promoter, where is your role now?
but the directions have been issued against me, my lord. And for that, I wanted to file an appeal. The appellate court obviously could not go into the merit of the case to adjudicate this issue because of this, the section 5. But 5, as per my submission, my lord, will be applicable only for filing appeal by a promoter. And here the petitioner is not a promoter. That is her case before the tribunal. And this court will have the power to have jurisdiction to set any malafide or my lord, because
There's no malafide. Where is the malafide?
because my lord, the RERA did not take into account that the petitioner is no longer a
No, who is acting malafide? Malafide includes an intention. Who may be made a party by name? This is only the owner. He is not taking a decision.
my lord, this fact was brought to the notice of the RERA.
So if you are saying that you are alleging malafide, first you show us the statement, then you show us the party by whom against whom malafide has been alleged, whether it has been made party by name. We have checked this, you have not made.
My lord,
At best, you can make a case of malice in law. That also we are doubtful.
my lord, the complainant is made a party here also, my lord.
The complainant will not act malafide. He is your adversary.
My lord. So the present,
Malafide will have to be of the authorities or the decision-making body.
my lord, the body was aware that the entire liability has been transferred to the new promoter. Why he has not been brought on record?
What is your prayer here? What do you,
my prayer is only limited to the extent that I may be allowed to file the appeal. That the judgment and order passed by the RERA may be adjudicated by the appellate authority and may be determined that whether I am at all liable to pay, because the entire liability has been shifted to the new promoter.
where is the bar for appeal?
That is, my lord, in section 43(5), but that is by the promoter.
No, where is your bar? Why can't you go for an appeal?
I can.
When
go,
you need a direction from this court?
my lord, I can go, but I have to deposit the amount.
Then?
That is the difficulty for which.
So you want an exemption from the deposit?
My lord, because I am not a promoter. And how can I make the deposit, my lord? Now entire the project has been taken over by the new promoter. I cannot make the payment. This is a practical difficulty which.
Third, MSP Chakraborty, Senate Counsel for the petitioner. Full stop. The deceased husband of the petitioner was a promoter and had undertaken a construction of a project, namely Nayana, N-A-Y-N-A, apartment, which however could not be completed, as a result of which the deceased husband had entered into a registered agreement with another promoter,
Madhav Sharma.
namely Madhav Sharma, who had undertaken to complete the project. Full stop. However, on certain complaint made by one of the purchaser of a flat with the real estate regulation, with the real estate,
Regulation and Development Act.
no, what is the authority name? With the real estate regulatory authority, comma, notices has been served to the petitioner in spite of the fact, according to the petitioner, no liability can be settled with her. Full stop. However, comma, there has been an adjudication by the RERA requiring the petitioner to pay compensation. Full stop. It is the case of the petitioner that an appeal is prescribed, comma, the same is available only to a promoter. And as per the petitioner, comma, the position of the promoter has already been shifted to the person with whom the deceased husband of the petitioner had entered into an agreement. Full stop. The petitioner also, the learned counsel also submits that to maintain an appeal, comma, there is a requirement of a statutory deposit, which is otherwise not possible for her, who is a widow. Full stop. Para. Issue notice.
The project has been taken over by the new promoter.
We already said, issue notice returnable by the facts projected may also involve the issue of maintainability of this writ petition. Full stop. Para. Be that as it may, comma, keeping the maintainability of this writ petition open, comma, issue notice returnable by 4 weeks. Steps be taken for service of notice upon the two respondents by registered post PTAD. Steps by Monday.
The prayer for interim may be considered on returnable date.
Do not make any statement. Let us see. Yes, next.
Please, Your Lordship. Your Lordship, my senior is on legs in another court, Your Lordship. Let the matter be taken over some other day, Your Lordship.
Which date?
Lordship?
Which date? Tell us. Mr. Gaur, you are there.
I am corresponding in item number 14, my lord.
What are the matters?
My lord, actually, there is a dispute regarding, my lord, the management of one temple, my lord, Sitaram Thakurbadi in Fancy Bazaar, my lord. This petitioner has already, my lord, admittedly, he was appointed by the, my lord, the committee, my lord.
Okay.
And
Then
he has
Mr.
been-
Chaudhary has some difficulty today.
My lord, a date may be fixed, any date, my lord. I mean,
Tuesday?
after the.
Tuesday.
What?
To Bihu vacation, can it be?
My lord, date also.
Okay. A prayer for adjournment has been made on behalf of Sri K. N. Chaudhary and the senior counsel for the petitioner. Sri J.C. Gaur, learned counsel for the private respondents, is present. So is Sri B. Deori, learned state counsel for sub para, has agreed to by the parties list on 19th of April.
Lordship.
Wednesday, 19th of April. Yes.
Deeply obliged.
Is there any interim order?
Interim order is there.
Interim order passed that day. Is it?
It is already
লিখিব নালাগে। Yes, madam, what is this?
My lord, this case is covered by a Supreme Court judgment. Finally, the matter may be taken up for hearing any other day.
Who's for the other side? Madam says that it's covered by some Supreme Court judgment. Are you aware?
Lordship, actually, Mr. B. Gogoi appears for this.
We will have it some other day. Ask Mr. Gogoi, they'll take care for final disposal if it's covered.
Lordship.
What is the judgment reference?
Not aware about.
You bring it. Your name.
H. Jane on behalf of Miss N.
H. Jane.
On behalf of N.
MS H. Jane, Senate Counsel for the petitioner submits that the issue involved would be covered by a judgment of the Honorable Supreme Court, full stop. Let this matter be listed on when?
5th next week.
Lordship, can it be after Bihu?
We'll have it on 19th of April.
Highly obliged.
May I please kindly pass over the matter for time.
Timing is not possible today, madam.
Kindly fix the date.
What is the subject matter?
This is an eviction.
Eviction.
Eviction matter. Petitioner in the process of our residual length more than 6.
A prayer for adjournment has been made, full stop. Sarah, made on behalf of the petitioner, full stop. Based on list after a week, 1 week.
Common advocate was asked to give inspection.
PNRD. Dr.
My lord, I have received some instruction, my lord. I like to file my affidavit, my lord.
What is the matter?
Matter is, initially 2 FETs were allotted, my lord. Thereafter, now under World Bank scheme, my lord, PWD department and the area society, they are developing the market, my lord. The main issue is that, my lord. Now, filing this writ petition day 1, there are vacancies there, my lord, reserved vacancy. No, we were earlier occupying. For 1 year, it is also mutated in our names. Now, in the name of development, they issued a notice. They vacate, we will develop it. Now it has been already developed. Now, question is since the year 2000.
It has not been given back to you.
No, not
You don't
given to
propose
anyone.
one.
Because it's under developing stage, my lord.
No,
And
after the development is over.
there are some other allegations are also there, my lord. Because
Okay, you
as
file
per
your
the-
affidavit.
yes, as per instruction, there are government.
Standing Counsel, PNRD department submits that instructions have been received. Full stop para. He pays for and is accordingly granted 3 weeks time to file the affidavit in opposition. Is there any interim order, Mr. Mahmood? No. Yes. File your affidavit.
Yes, my
Let him also know what
my
are your
lord,
reasons.
my lord. Obliged.
But if there are no serious reasons, you should not deprive the petitioners. They were already having the
Yes,
vita.
Otherwise, we don't have any
All
problem.
application this and that is always there.
These are also mutated in our names. Both petitioners are government.
And whatever problem you have, you can sort it out with them, but not deprive of them. Okay, takes.
My lord. We have vacated only.
Yes.
Either
Next.
Obliged.
Item 20. RDB AR Tahbildar non-appears for the petitioner on call, whereas the S. Kotokilan, standing counsel AEGCL, along with Sri B. Deuri, London State Council, Government Advocate are present. Sarah, in the interest of justice, list after 2 weeks. Is there any interim order?
No.
You have filed your affidavit?
Yes, yes, we have filed.
Oh, you have filed it. Okay.
Please, Your Lordship.
Yes.
Lordship to the last order you.
We have perused.
In this order, my lord, I need some more time. We are talking with the department, my lord.
Bill has been admitted. May I, Lordship, kindly peruse page 14.
Yes, we'll fix a date immediately.
My lord,
after the
regarding
view.
the admissibility, I'll take a.
Sri S. Datta, London Standing Counsel, PNRD Department, prays for and is granted further time to get complete instructions and file affidavit of opposition. Full stop. Please, on 21st of April, is it okay?
My lord,
Or maybe 25th?
25th, my lord.
25th of April.
Okay.
Tuesday.
Hello,
25th, no, 25th, 26th,
26th,
Tuesday, Wednesday. 26th.
my lord. Hello.
Hello.
Yes, yes.
In this case, Lordship, the petitioner of
Your, nothing is coming from you?
No, nothing is there, Lordship. Basically, the deputy commissioner is required to see whether there are actually land erosion affected people or not. And if that so, under this, whether grant of patta to them can be.
My lord, kindly see Lordship, page 62, Lordship.
Yes.
The court's order, Lordship.
Hmm.
Lordship, and 63, Lordship, from second paragraph, Lordship.
Yes.
Lordship, the counsel for the petitioner now, along with the memo produced by the written additional deputy commissioner Hailakandi, the assistant that 21st June 2014, the court settlement officer filed, which disclose person who have to be rehabilitated, and the report is also said that land in Dag number 7, which is 6 bigger 7 kata Totak, was found suitable for allotment of the patta. In view of the said proceeding, the counsel for the petitioner submit that the request made in the report to complete Lordship. Then Lordship, this court directed to comply this there to this order, Lordship. Because of Lordship, there is a 100 Lordship. One is 1999, one is 2005.
Now what has happened?
Now, Lordship, I kindly see an exact 10, Lordship.
You have seen?
Lordship, an exact 10, Lordship. Then, Lordship, this is the Lordship latest Lordship development, and this letter was issued by the deputy commissioner Lordship himself. The petitioner is number 1, Lordship. Kindly see page 66, first page, Lordship. Musharraf Ali Chaudhary, Lordship. And petitioner number 2 is the 26th, Lordship. They have selected 4, Lordship, for
Ranjit.
Yes, Lordship. Granting patta, Lordship. This is letter, Lordship.
No, 26 is what is his name? Ranjit Sinha.
On this here, Lordship. And Lordship, number 1, Musharraf Ali, Lordship.
Yes, you get your instructions.
Lordship.
Okay.
Yes, yes.
Because Lordship, they are in the meeting, Lordship. They decided
TKS
to.
Barwat and its state council prays for and is granted further time of 3 weeks to obtain the instruction. This will come.
My lord, this matter pertains to an application which the respondent number 3 has triggered the Micro and Small Medium Enterprise Development Act 2006.
You are the refinery.
Yes, ma'am.
What is your difficulty?
My lord, they do not have any locus to file an application under section 18 for the center. That is the difficulty.
Oh, this is MSME.
Yes, MSME.
But what about the recent judgment of the Supreme
No,
Court?
my lord, we will differentiate that. That is not at all covered in our case. That is altogether a different subject.
No, sir, not on the subject, on the principles.
On the principle as well. We are on a different footing. My lord. Because they have to satisfy the provisions of MSME Act. Before satisfying that, they cannot jump and file an application. If that be the position, my lord.
But they are a recognized MSME.
Maybe.
We are not disputing the recommendation.
After it's, if you not dispute that the entity is an MSME,
Hello.
and what is the extra criteria they need to fulfill?
Yes, I'll bring on to the government.
Then let him come today, it may not be possible. Second half, we have some difficulty, but we will be sitting till 2 o'clock. Let us try if he comes
Yes, yes, Lord.
after some time.
My lord, only one small difficulty at 2:30, we have a matter at.
We are sitting till 2:30. Till 2, we are continuously sitting.
Oblige.
My pleasure also.
Affidavit filed, reply filed.
File, your lordship.
Yes.
Also, this is a case wherein the authority has invited for supply of furniture for a school also. Petitioner, earlier they have called for NIP, and petitioner being L1, petitioner was not given the work on the ground that the also will kindly see page 16, first NIT. First NIT 5/7/2022.
No, we are taking it for what purpose? See?
Your
If
lordship can take
lordship
it up.
dispose this matter, then lordship may finally dispose this matter to the HL.
It will be possible. How long will you take?
I will not take so much of time.
Now we want to at least do we have completed the motions and submission also, but we don't want to leave any urgent matters pending.
So immediately, lordship, after next week.
Lordship, what has happened here, your lordship, this is a matter relates to supply of furniture, your lordship.
Yeah,
Our only apprehension, school, your lordship, our only apprehension is that a 31st March is there, your lordship, the amount, the money can, your lordship, go back. Your lordship.
Money is given by whom?
But it is by the state government, your lordship, under a.
Would ensure that the money doesn't go back.
Lordship, in case of furniture, I am confirmed, lordship, I have taken the confirmation. That I am losing the lordship bid. So, lordship, it will not go.
Now we can make an
Lordship can, lordship.
protect the interest of the parties.
And
But if you don't take much time, we can take it up for day itself. Not issue.
we will not take much time, your lordship, hardly 15 minutes. He gets or someone else gets, the school has nothing to do with that, your lordship.
What is the main ground of challenge?
Main ground of.
You have been disqualified.
No. I am L1 habitat. First tender, second tender, I am L1. First tender, they have cancelled without giving us the work order. Only ground that the furniture should be of Godrej and Wipro and other things. That notification has, before that it was cancelled, that there is no question of Wipro and other things is not necessary. General furniture is necessary as per their specification. That has been cancelled. After reading that, they have cancelled tender protest to allow work order to someone. That's your case. Next tender invited. Next tender also I am L1. I am L1. They have given a message. After L1, they have not issued a work order. They have a WhatsApp message to me and the other person given a message. I have given 2 days time to give the furniture, sample furniture to the authorities to inspection by them. I have given 3 days time, that is on the Friday, Saturday, Sunday, Monday, I have given the furniture, sample furniture. They have said in the affidavit, they have inspected the furniture from engineers that they found that some furniture are not as per specification, drawer is not fitted and other things. I have hurriedly supplied some furniture. As per rule, lordship will kindly see, it will clear everything.
What are the grounds of rejection? The furniture were not properly fitted.
No, before that.
Not rejected yet, your lordship.
Lordship kindly see page 26. Page 26 of the report.
Yes.
Page 26, lordship will clause D. Lordship got it. The guideline for procurement of furniture of others of Vidyalaya. Lordship got it.
This is.
D, lordship. Purchaser order will be issued to the lowest bidder.
Yes.
If qualified as per terms and conditions of the quotation, call a letter. On delivery of the furniture at the school, same shall be inspected. If any found to be inferior to the specification or defective, will be rejected. Such item will be replaced. Also confirm the laid down specification. If they have rejected the furniture, they have to offer me that you should give the furniture as per quality. They want the negotiation with the L2. When I am the L1, lordship, the CBC guidelines specifically stated, I have annexed the CBC guideline also. They can negotiate with me only. They cannot negotiate before settlement order has been issued with L2. They cannot take the furniture of L2. From this section, it is clear that they want to allot the furniture to L2. That is why I'm before this honorable court. And what they have stated in their affidavit, Lordship, kindly see.
Mr. Goswami, who are the parties?
Party are the Adolf Vidyalaya and the myself, Lordship, and the comment. Because what order has not been issued, Lordship.
You are a government-run, controlled
Lordship.
school.
Lordship.
School, your lordship, it is, your lordship, there is a tender committee, your lordship. The committee is headed by deputy commissioner, your lordship. And ADC also a member, your lordship. I am the principal of this headmaster. of this
What did you say? Are you willing to?
Lordship,
What is your
we have
difficulty?
not taken any decision, your lordship. This case is premature. It is still.
No, you must be having some instructions.
Lordship, I have filed my.
No, what is your instruction?
My instruction is this.
Apart from your technical submission that is premature, what
Lordship,
do you intend? He has shown us one of the clauses of the tendered
Lordship.
conditions. We have not seen the others, there may be others, but this as per you have been given the privilege and liberty that if you are not satisfied, he'll be replacing those. Now, you have not gone to that stage.
No, that we have not gone to this stage. What has happened, your lordship, in all the tenders of this nature, furniture of supply, the problem is this, your lordship, we have found that, your lordship, the committee has found that in many cases, your lordship, the quality is very bad, your lordship. Therefore, your lordship, this is not the only case where, your lordship, before your
No,
lordship,
is there any finding by you that the quality of the furniture,
there is a
which
finding by, your lordship, there is a finding by the ADC. That an office note that the quality of the goods is not good, but that has not been placed before the tender committee till date, your lordship. It is still in the office note. Now, your lordship, a request was made to both the tenderers, your lordship, that you furnish the samples. We will go through that.
Yes.
Rather than, your lordship, after finding it, the conditions bad, your
then
lordship.
what had happened?
Then, your lordship, he submitted some documents, some furniture, sample of furniture, and other also, your lordship. On the basis of that, ADC verified it and submitted a report saying that he has not submitted sample in respect of some of these specifications and some are not good. That is there in my record, your lordship. And on that basis,
Now, is the finding specifically on the issue of quality of the goods
quality.
or on lack of certain fittings?
No, your lordship, that is on quality. your
Quality
lordship.
also.
It says, your lordship, quality is not good, your lordship. And on the basis of that, his suggestion is that, your lordship, that it should be given to the L2, your lordship. This is his suggestion. But that has not been placed before the tender evaluation committee.
You are yet to act upon the
Act
issue.
upon it, your lordship.
So we'll do one thing. Since he has expressed some predicament or prejudice at the time of delivery of the samples, we give him a reasonable time. Instead of this matter being kept pending,
Lordship.
we give him a week's time. Week's time will be enough for you.
Lordship.
You give the samples, let them make a reassessment. If they are satisfied, matter ends there.
Lordship.
If they are not,
That
then
will
we'll
do. That
adjudicate the
will
matter.
Yes, Lordship.
You don't have a difficulty there?
No, no.
Should not have.
Lordship. Only thing, kindly see their affidavit, Lordship. He is
No, it is okay. They'll
no.
consider afresh.
What he is submitting, Lordship, the furniture is not quality. The specification has been mentioned in the annexure A. One drawer was not fitted. One.
That is the question we have asked. That is the question we have specifically asked. Whether your comments of not being eligible is on account of the quality or account of some fittings. The question, the answer has been replied that it is account of the quality. So now we are giving you a week's time. It's not a day or two. You get a week's time. Supply it. Give the samples.
2 weeks at least, Lordship. Because we have to make the ready furniture. 2 weeks as per their specific.
10 days time.
10 days.
10 days from today.
Old furniture should be returned, Lordship. The defective furniture should be returned. We should give it a new furniture.
You will be giving new furniture, obviously. Heard free SK Goswami Learned Counsel for the petitioner. Also heard Prayas Bothakur, Learned Counsel for the respondent number 5. 5?
Lordship.
Who is the principal of the Adarho
Lordship.
Vidyalaya Dolgaon in the district of Godorong. The state respondents are represented by Sri C.K.S. Barua. Union of India is also. Union of India?
Lordship.
Union of India.
Union of India.
Who was there? MSA Gan is present for the Union of India. 3 B. Gogoi for correspondent to the Rastriya Madhyamik Shiksha Abhiyan, and 3 C.K.S. Barua for the state respondents. 3 and 4. Full stop, para. The matter pertains to a tender process for supply of furnitures to various government schools, including the school in question. Full stop.
This school only.
No, only this school, only this school. Others of Vidyalaya Dalga.
Matter pertains to a tender process initiated by an NIT dated 15/7/2022 for supply of school furnitures for the respond number 5 school. Full stop. It is the case of the petitioner that in the first NIT, though the bid of the petitioner was found to be L1, the same was cancelled, whereafter another process was initiated by a notice dated 20/10/2022. Full stop. The case of the petitioner is that even in the second process, the bid submitted by the petitioner has emerged as L1. Full stop. However, there is a note by an authority of recommending rejection of the bid of the petitioner on the ground that the sample supplied were of inferior quality. Full stop. The learned counsel for the petitioner submits that apart from the fact that very less time was granted for making the supplies of the sample, the rejection is not on.
Rejected, Lordship.
Huh?
Not yet
The recommendation is not on the basis of quality, but of certain fittings,
Effects.
certain lack of fittings which could not be done because of the constraint in time. Full stop. But on the other hand, the Botakur, the learned counsel for the respond number 5, submits that the authorities who are competent to take the decision are yet to take such a decision, and the matter is only at the stage of a recommendation by the additional deputy commissioner. Full stop. Para. Be that as it may, this court is of the opinion that the dispute may not be required to be adjudicated in view of the directions which is proposed to be passed. Full stop. Para.
As well as guideline, Lordship, record guideline.
This court is of the opinion that the petitioner be afforded another opportunity to place the sample of the supplies which he proposes to make within a period of 10 days from today, which may be.
Date of receipt certificate, Lordship.
Right, today
You will take time, you will take.
we'll
time.
ensure that you get a certificate by 3 o'clock today. From today. And there will be a fresh inspection, public assessment of the supplies made and a decision be taken. Full stop. Para, it is interest to state that such decision be taken independently and fairly. And if the same is in favor of the petitioner, the taken and the outcome may be informed to this court on that by the next date. Full stop. Para. Para, in view of the above, the petitioners may make the supply of the sample within the period stipulated above, and a decision be taken thereof within a period of 2 weeks thereafter. Full stop. The matter will be listed for consideration on today is 31st, and 10 days and 2 weeks. We will have it on 3rd of May. 3rd of May.
Only thing is, Lordship, they may take again whole furniture should be assembled.
That he will go.
Also be recorded, otherwise they are paid.
The sample which were supplied earlier by the petitioner are required to be returned to the petitioner,
If it has already not been taken away.
if not already returned.
God bless you.
Yes.
Interim to continue by this time,
What was the interim order?
not to settle with the other person.
Interim order, Mr. Borthakur. Interim order passed earlier to continue till the next day.
God bless.
Yes.
So in this case, earlier petitioner is appearing in person, but High Court Legal Services Committee has engaged me as legal aid counsel. What I have gone through the documents, I think the petitioner is a firm, is represented by proprietor. Firm is not entitled to get the legal aid, Lord, I think.
You don't need to argue on that. You have been appointed, you do your duty. Whether he is entitled to or not, you place your fact. You don't need to go into those aspects.
Well, no,
Where are you concerned with your appointment?
he applied in his own name, not in the name of
Doesn't
firm.
matter, doesn't matter. Yes,
That's
tell
why
us.
perhaps it is, I am engaged, Lord.
It's only a kind of a same, almost a quasi-administrative job. What is your instructions?
Lordship, instruction, I'm just studying lordship, but thing is the lordship, the similar matter I have disposed of some days back lordship of MES lordship. Where thing is that.
This is who is the other respondent?
Responding is basically. Ministry of Defense, Commander, second is Commander Work Engineer Jurhat, Chief Engineer. So,
It's only a matter of arbitrator's appointment.
And in fact, lordship.
Take one instruction and dispose this off.
Yes, let us file our affidavit and.
There's no question of fighting. Take instructions. Dispute is there. He wants appointment. You have not been appointing. Application filed at the 11.
As
You don't need to appoint.
as per page number 6 of his reputation lordship, one Chief Engineer Silong Jom has been appointed. Now he is challenging the competency of that arbitrator. Now thing is that lordship, if he is of the same department, that does not make him bias. Only
You can raise an issue of jurisdiction, not here, not in an application.
And
under
secondly, lordship,
11.
in the.
You said that it's already been appointed.
No, as per the page number 6 of his reputation, let me kindly see. The last part, lordship, and whereas the contract cited above is subject to so and so general conditions of his presides for reference of dispute and difference arising and or in connection of the said condition with the said contract, sole arbitration as mentioned in contract agreement, and whereas in accordance with the said contract agreement, the authority mentioned for appointment of sole arbiter is the Chief Engineer Silong Jom. Now therefore, by virtue of the aforesaid, we hereby request you to appoint sole arbiter to execute.
There is no challenge. There is no appointment.
Chief Engineer Silong Jom, I think.
Where is the appointment? You have to appoint it. You have not appointed. You get the instructions whether
Let me
appointed
get
or
the
not.
instruction, lordship.
Get instructions, a very small matter.
Secondly, we have the list of panel of arbitrators also, lordship besides.
See, panel of arbitrators will come when there is no arbitrator specified. They have in their contract one arbitrator already. You just need to appoint.
Let me get the
If he's already
instruction.
appointed, then Lord,
The Haloi, the net counsel, legal aid counsel
legal aid.
has appeared along with the petitioner, who is also present in person. Hrishikesh Barua prays for some time to obtain instructions on the steps taken for appointment of arbitrator. Full stop, para. Based on, will give a date.
For Bihu Melody, it put it.
No, lordship, after Bihu, lordship.
Have it on 28th of April. Wednesday,
Most of lordship.
28th, first then.
20th or 19th, or then 21st.
Malad.
Friday.
Most of lordship.
Much.
Petitioner before Lordship, my lord, unfortunate wife, wherein the husband has been missing. My in the last occasion, instructions were sought for my lord, and in this connection, they have filed, the transport department has filed their affidavit, my lord.
Oh, your vehicles were used by the IOCL.
Yes.
Then there was no change. Then, yes, yes. What is your take?
Lordship,
Anybody has filed affidavit?
Lordship,
On the last occasion, your lordship was pleased to direct the OC Patase Lambari to investigate the matter and place a report. So accordingly, I have communicated and they have done so, your lordship. May I read, your lordship?
Yes, please.
Here on that, on 4/9/21, the complainant Sri Nilakanta De Biswas, son of late Paresh De Biswas of Kahilipara, Colony Bazar, Guwahati, PS, Pataselambari, Kamrup, closed the FIR stating that at about 4 p.m. on 3/9/21, his elder brother Hilon De Biswas left his house with motorcycle number such and such, but his brother did not come back home till 12:10 a.m. of 4/9/21. The complainant also mentioned in the FIR that he received information from Jalukbari PS that the motorcycle used by his brother was recovered by police at about 11:10 p.m. of 3/9/21. The complainant also stated in the FIR that his elder brother Sri Elonde Biswas had been suffering from some mental disturbances. Based on the FIR, the case is registered by Photoselambari such and such, and that the investigation in the course of an investigation, it is known from the Jalukbari outpost. Constable number
Yes,
3.
we have read this.
Yes, your lordship.
There is less hope of recovery.
Yes, your lordship.
What do you say? I will see.
There is a recent development, my lord, wherein the IOC has written a letter which has been received by the petitioner, my lord, for extension of
Extension of lease.
the contract, my lord.
Very good.
And regarding this, my lord, we have to file our reply. We went there to file the reply. They said that as the matter is sub judice, if the court take a call, we'll.
So we can clarify this part.
Yes.
Tendency of this case may not be a bar for consideration.
Consider.
Heard Sri A.K. Bhuya,
And that, my lord, bank account has to be operated because I have given a specific statement in paragraph 20 of the rate petition, my lord. I didn't identify the bank. And I have to be the custodian because these are exclusive license and all such thing has to be renewed. So for that purpose, my lord, the custodian of the.
Is the bank a party here?
Yes.
I'm appealing for the bank.
Yes.
Provision, your lordship. I think in the permission to operate the bank account can be done, your lordship. Yes, he can claim the amount which is left over in the account. I think we can, but operating a account on another name.
Where is the IOCL? And for the timing, we could have done one thing. The account will be in the name of the present petitioner.
My lord, that account, my lord.
But that will be utilized, allowed to be utilized for the.
The problem is, my lord, the account is in the name of the proprietorship concern. The proprietor was the husband.
No, since the husband whereabouts are not there.
My lord.
And it's a sole proprietorship, so it will be not be proper on the part of the court to let bank account be operated by any other person. We can allow, he said that the amount can be withdrawn by you. That's not a big problem, but we can allow, we can direct the IOC to recognize an account in your name.
Yes,
and
that will be fine.
But IOCL,
IOC.
MK Chaudhary. Can you inform him? We can have it after some time.
Yes.
So what the matter? I don't think IOCL will have a problem. Since this has come from the IOCL itself.
Yes.
After some time?
Yes.
We'll not take the break today. You can come at your ease. We'll sit till 2 o'clock. After 2, we'll not be able to. So, try to locate him and come.
Yes.
I'm sorry, your lordship. I'm sorry, your lordship. I was on legs in other court. It was passer for time being, your lordship.
Okay. Where is Mr. Sayola? No, not it. K.K. Sayola. Where is your colleague?
He was here only just a few minutes back.
Mr. Sayola? He's questioning your eligibility to invoke that thing. You are an MSME. isn't it?
MSME,
You get the benefit of the tax.
Yes,
And he says that you are not fulfilled the criteria to have
no.
have your
Even if he is questioning it, this is not, in all humble submission, Your Lordship, this is not the code of Your Lordship, because in my humble submission, this particular submission, he can take it up before the MSME Facilitation Council, where he has filed a written submission also at page number 70 of the writ petition, where he has submitted to the jurisdiction of this Honorable MSME Facilitation Council. And in the prayer portion also, Your Lordship, he has specifically stated that since there exists a separate arbitration clause in their agreement, so if any dispute arises between us, that is subject to clause, that particular arbitration clause, and not the MSME Facilitation Council. But very recently, in terms of the
that is
judgment-
he says the Supreme Court is not applicable, facts are different.
No, Your Lordship. No, Your Lordship, because if Your Lordship, we have to go by the prayer portion of this writ petition, Your Lordship. If Your Lordship peruses to the
No, he can make an endeavor to distinguish a judgment that you cannot prevent.
No, I'm not saying, I'm not denying
But
that.
how much time will you want both the parties?
Will take time, sir. Some time will.
Today it may not be possible then.
Lordship, the thing is, the matter is, the petitioner, 19 lakh rupees is not a big amount for them, but for the petitioner, it's a very huge amount. And that.
You tell us when can you do? But we'll have to give some time to both to you, both of you.
Tuesday, Your Lordship, if it is possible.
Tuesday.
Because last date, my lord, I prayed after new vacations. He pressed for a date before that.
Tuesday we may fix. But if it's not on Tuesday, then definitely we'll go after the Bihu. Of course, the 11th is, I think, it'll be a better day.
Your Lordship, I'll be out of station from 7.
My lord, after Bihu,
11th, because 4th, 5th, those days,
I
as you
understand, Your
know.
Lordship. I understand.
But 11th, relatively, we have a free day. 11th, you are not here.
I'm not here, Your Lordship.
Then 28th, 20, Thursday,
27th, Your Lordship, if it is possible.
Thursday.
Thursday, Your Lordship, a hearing day.
Yes, we can have Thursday.
it is better if the court accommodates 3rd of May rather than a 27th, after 4 or 5 days. If possible.
Depends on your colleague.
The motion day, Your Lordship, again.
Third, no, don't take a third day, motion.
On 4th,
4th is okay. 2nd is also okay for us.
4th, sir.
4th, okay. Heard. Three. This is item number 23. A.K. Sayola, Learned Counsel for the petitioner. Also heard. With CGC,
Miss A. Gayan was there.
what's CGC, full stop. R. Bora,
D word.
D. Bora, sorry, D. Bora has appeared for the, that's one number 3, full stop. The Learned Counsel for the parties have jointly submitted that the matter is urgent in nature and can be traced out at the stage of admission. Full stop. Para. List for admission hearing on 4th of May 2023. Interim order passed earlier to continue till the next day of listing.
It is your lordship.
Arbitrator appointment.
Yes. Last occasion, none had appeared for the respondents.
Names, what item number 40? Who's there? MZ Ahmed, AM Doctor. Last occasion also they were absent. Where is Mr. AM Doctor? Yeah, so you numbers of AM Doctor MZ Ahmed. Mr. Sayola, Mr. MZ Ahmed, is he there in the court? I think he sits in the same room. Oh. His junior, Mr. A.M. Datta. Or Madam Datta, Meena Datta, is she around? Wait for a while. You try to, huh? After a while, if they are around, you can pass some effective orders.
Or a date may be fixed.
Wait for a while, we are around. Try to have his number and give him a call, Mr. M. Datta.
May I please, Lordship? Respondent supposed to file affidavit, Lordship.
Yes, GMDA. Demolition is
Yes,
is
Lordship.
under challenge. You are protected by an interim order.
Yes, Lordship. Interim may be. Lordship.
GMDA, who's there? GMDA. Mr. Nayak, Mr. Bora. Do MSD does counsel for the petitioner is present. None appears for the GMD in spite of names being shown in the cause list. Full stop list after 2 weeks. Para, interim order passed earlier. Then extended till the next date.
Obliged, Lordship.
Lordship, I have obtained-
Supplementary.
Yes, Lord. Along with my report, Lordship. Yes, sir.
Lordship, 439 application, Lordship. Here, my case, I'm relying on 4 points, Lordship, here in this case. First, Lordship, I'm having valid drug license. That is not disputed. And their allegation that I used to purchase medicine from Mogrebali. From Mogrebali, one of the co-accused from whose possession some articles were recovered. So it is their allegation that I sometimes used to purchase from Mogrebali. And from the evidence, Lordship.
What is your name?
My name is Aminul Islam, Lord.
1 minute. You are Aminul.
Aminul Islam, Lord.
Allegation is that used to purchase from
Mogrebali.
Mogrebali. You are a license holder.
I am also license holder, Mogrebali also license holder. Given time, license was also valid, Mogrebali.
Yes.
And there is no specific incident mentioned by the investigating agency that when I have purchased, what is the quantity, nothing is there.
No specification
Good.
of offense.
Okay. So this is my first case that I am having valid driving
And
license.
since you have the license, simply purchase will not make it, it cannot be termed as an offense.
Yes, if I violate the terms and condition of the license, then I will be liable, Lord. They
This
have
is
to show-
otherwise this substance in question is it something which can be prescribed medically?
Medically, is a cough syrup, Lordship. The cough syrup.
What is the name?
Relax cough syrup. Lordship.
Relax cough.
Yes, sir.
Okay, then
And then my second case is there, Lordship, that the contrabands were not recovered from my possession or more from my pharmacy.
not recovered from possession of petitioner.
Yes, Lordship.
And even after that, my pharmacy was searched, my house was searched, nothing was found, any contraband was found.
Okay.
And say third point, my third point is lordship, co-accused Nure Zaman and Tohidul Alam. Co-accused Nure Zaman and Tohidul Alam, they were enlarged on bail, released on bail lordship. I am on similar footing. They were also owner of pharmacies. They are against them also.
They are released on regular bail.
One is regular bail, one is anticipated bail. Nure Zaman is regular bail.
Anticipated in NDPS matter.
Yes, Tohidul Alam was granted anticipated.
Maybe there is no allegation against him at all.
If your lordship peruse the charge sheet here, your lordship will find that allegations are same. That we used to purchase medicines from Mugreval. This is the allegation. Basically.
Okay. Then fourth.
And fourth is lordship, delay in conclusion of trial. I am in custody for 2 years, 5 months, 24 days. And only 3 witnesses were examined out of 11 witnesses and 69 documents yet to be exhibited.
Sixty-nine documents exhibited.
Yes, 69 documents are prosecution relied on as per charge sheet lordship.
Okay, not proved as
Not
yet.
proved yet.
Yes, Mr.
So just I'm placing the 4 judgments before your lordship. Other judgments already I have placed before lordship that regarding delay in trial, that I am just placing. Here also commercial quantity was involved.
NDPS matter.
NDPS matter. Less than lordship 2 years they were released on bail. I am above 2 years.
Which is until matter, the last one.
4 judgment I have given. Lordship will find Chittaranjan Biswas first case. In second paragraph, your lordship will find they were accused of punishable under section 21C. In this case, they were arrested on 21/7/2018 and released on 7/2/2022. That is 1 year, 7 months of detention, lordship. Considering that only that aspect.
What is the date of this?
Chittaranjan Biswas lordship, date of arrest 21/7/2018.
Not date of arrest.
Judgment says 7 February 2020.
Criminal appeal. 245. Dated 7th April.
7th February.
7/2.
Oh, yes, ma'am. 2020. Then next judgment.
On the ground of delay.
Delay.
It's a demerits.
First page, last second paragraph, your lordship will find appellant was arrested on 21/7/2018 and continues to be in custody. It appears that out of 10 witnesses cited to be examined in support of the case of the prosecution, 4 witnesses have already been examined in the trial without expressing any opinion on the merit or demerits of the trivial submissions and considering the facts and circumstances on record. In our view, case for bail is made out. We therefore allow this appeal and directive. And second order, your lordship will find.
Nothing has been stated why.
That in other cases, your lordship will find that.
Case for bail is made out. Yes, why?
Yes, in first case, it is not there, but detention period, it is mentioned, lordship.
Next.
Next, your lordship will find Nitish Adhikari.
First is.
Here also 21 C was there. That page, next page, first paragraph, your lordship will find during the course of the hearing, we are informed that the petitioner has undergone custody for a period of 1 year, 7 months as on 9/6/2022. The trial is at a preliminary stage as only one witness has been examined. the petitioner does not have any criminal antecedents. Taking into consideration the period of sentence undergone by the petitioner and all the attending circumstances, but without expressing any view in the merit of the case, we are inclined to grant bail to the petitioner.
This is on the ground of delay.
Yes. And the third case, your lordship will find Gopal Krishna Patra. Here also, section 8, 20, 27A, 28, read with 29. Last line of first page, I'm reading, lordship. Considering the facts and circumstances.
Just a minute. Gopal Krishna Patra.
Lordship.
August.
Lordship.
Yes, please. What has happened?
Considering the facts and circumstances on record and the length of custody undergone by the appellant, in our view, the case for bail is made out. And for judgment, it is relevant, lordship, in my case, because it was solely on the ground of delay.
What was the offense here?
Here also
Commercial quantity?
commercial. Mohammed Salam, your lordship.
No, in Gopal Krishna.
Yes, here also commercial, lordship. Section 8, paragraph 2, your lordship will find first page. Section 8, 20, 27.
28, yes.
20.
Muhammad Salam.
Yes, Lord.
Muhammad Salman.
Salman Hanif Sheikh.
Gujarat.
Lordship.
LP number 5530. (22.8).
Lordship.
That's what has been said here.
Yeah, here punishable under section 8C, 21C, 22C, and 29 of NDPS Act. Second page, your lordship will find first line.
The earlier was by the same bench.
Earlier one.
Same bench.
Yes. Yes, lordship. No, here lordship different bench.
No, Nitish Adhikari.
Nitish Adhikari. Yes, Nitish Adhikari is same bench. First line, your lordship will find the sections involved in this case. And third paragraph, I am reading, lordship. We are inclined to release the petitioner on bail only on the ground that he has spent about 2 years in custody and conclusion of trial will take some time.
Yes.
So these are the citation on lordship delay ground. And lordship, my drug license, that is not disputed by them that it is not a valid drug license. And if I am having valid drug license, lordship, then section 8 that will come into play, lordship, that if except in medicinal purpose, because this is the psychotropic substance manufactured drug which they have allegedly recovered, lordship. That exception will come into. And lordship, I have filed one additional affidavit, lordship, to bring on record the order passed by this honorable court granting anticipatory bail in Tohidul Alam case, lordship. Page 165, lordship, running page 165.
Hmm.
163, lordship, I'm sorry, 163. First page. So he was granted bail and that order was not challenged by the other side till date.
163 is not a bail.
163, Lordship.
Annexure one.
Yes, Lordship. In page 164, your Lordship will find, considering the submission made by, it appears that, last paragraph, Lordship, it appears that a petitioner has shown a good ground for his failure to appear before the trial court. Therefore, it is hereby directed that the petitioner shall appear before the trial court within next 10 days from today and on perusal on his personal appearance.
No, that's on a different criteria.
Lordship.
You come to 164, the first paragraph.
Lordship.
It is the court, the matter was in the, at the stage of trial.
Yes.
And he did not appear on notice. This is not be applicable. The pandemic situation was there. No, with the others have, you need not refer to Procedural. The Supreme Court matter, judgments, I think. You
It is
can
there,
base your
Lordship.
submission on.
Another judgment, your Lordship, will find that Nurejaman's order, Lordship. That your Lordship will find. 105, Lordship. That's from 104, Lordship. Nurejaman. Against him, that materials your Lordship will find 107, Lordship.
Bail order. Raise. Yes.
Para 11th, page 107, your Lordship will find.
Yes.
Keeping in view the above principle, let me consider the prayer for bail of the petitioner on the basis of materials brought on record. Pankaj Kumar Chauhan, intelligence officer NCB, received a secret information on 25/2/2019 that one Moghreb Ali, along with his two accomplices, Ziaur Rahman and Abdul Motleb Mir, were going to transport huge quantity of Recofax codeine-based cough syrup by his own vehicle bearing registration number so from Guwahati to Dhubri. Pursuing the said information, the NCB team intercepted the above mentioned vehicle and found accused Moghreb Ali, Ziaur Rahman, Abdul Motleb Mir in the vehicle and seized 600 bottles of codeine-based ASLAC of cough syrup, 1200 bottles of codeine-based Recofax cough syrup, and 758 methamphetamine tablet from the above three accused persons. Evidently, no contraband article was seized from the possession of the present petitioner, nor he was present at the place of occurrence. Accordingly, according to the learned standing counsel for the NCB, petitioner was arrested on the basis of statement of co-accused Moghreb Ali, who stated in his statement purportedly recorded under section 67 of the NDPS Act that he would sell 68 grams of methamphetamine tablets to the present petitioner. The petitioner in his statement purportedly recorded under section 67 of the NDPS Act denied such averment of the co-accused Moghreb. Therefore, materials on record clearly shows that no contraband involved in the case was recovered or seized from the possession of the present petitioner, inasmuch as admittedly all the contraband, that is 18,000 bottles of cough syrup and 758 methamphetamine tablets, were seized from the possession of other co-accused as mentioned above, except and purported statement of co-accused Moghreb Ali recorded under section 67 NDPS Act that he was supposed to sell the 68 grams of methamphetamine tablets to the present petitioner, which was denied by him. No other material has been brought on record to connect the petitioner with the recovery of contraband or the offense of the present case. In view of the above material, it is difficult to hold that the trial against the present petitioner may in all probability culminate in conviction. Therefore, I am satisfied.
Yes, we have read.
And another last, I am relying on Lordship.
This is on the ground of his non-recovery from him or his possession order.
Page 119, Lordship may kindly turn into. One one nine. Here also, Lordship, that factual part and other case your Lordship will find at page 111, Lordship. Facts of the case. In this case also, nothing was recovered from his possession. Other persons.
Which matter? Which matters?
This Maqbul Hussain, Lord.
Hmm.
And page 119, your Lordship will find they were granted bail on 2 counts. First, nothing was recovered from their possession, and the other persons were on bail. And in fact, in that case, they were on default bail. But in spite of that, Honorable Apex Court took considered that matter fact and release him on bail. Lord. My case also, nothing is recovered from my possession. 2 other persons are on bail. Lord. Similar to Maqbul, Lord.
But here, Maqbul Hussain was rejected.
Yeah, rejected. Then he went to Supreme Court. Lordship will find 119, page 119.
One on nine is the Supreme Court's order.
Yes.
Dated
Dated Lordship 13 January 2023.
31/23.
Lordship.
Yes, yes.
And in page 137, Lordship will find that one notification from Drug Controller General of India, it is there, Lordship, which says, Lordship, regarding that cough syrup and other Lordship. May I read, Lordship?
137.
Yes.
Yes, what is this?
As you are aware, there are number of cough preparations like Corex of MS so-and-so, Procedural of MS so-and-so, Kodokap of MS so-and-so, Codeine Lintas of so-and-so, moving in interstate commerce. These preparations contains, among other drugs, codeine phosphorate 10 mg as one of the ingredients. By virtue of the fact that these preparations contain codeine and its salt, they do not fall under the provisions of NDPS Act and rules of 1985, but they fall under Schedule H of the drugs and cosmetic rules and are governed by the said rules. Though stocking and sale of these drugs do not attract the provisions of NDPS Act and rules 1985, however, these formulations are prescriptions drugs and are not to be dispensed on the prescriptions of a registered medical practitioners only. Further, you may be already aware that under notification number so-and-so, under the Narcotic Drugs and Psychotropic Substances Act and rules 1985, certain preparations are exempted as manufactured drugs, provided the preparations contain the narcotic drug to the extent permitted. In respect of codeine under entry number 35, it is stated.
What is the substance involved here?
Codeine.
No, your
Cough syrup, that codeine.
codeine also.
Codeine. It is a manufactured drug, Lord.
Yes,
Codeine and
please.
narcotic drugs to the extent permitted. In respect of codeine under entry number 35, it is stated that codeine and ethyl morphine and their salt, including illegible all dilutions and preparations are considered to be manufactured drugs except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drug as per dosage unit, and which a concentration of not more than 2.5% in undelivered preparations and which have been established in therapeutic practice. The above brought to your notice for information and necessary action. So here, even if we assume that Moghrewal stated that I used to purchase medicine from him, cough syrup, that itself will not made out an offense, because at that time, Lordship, he was having valid drug license, I was also having valid drug license. So unless they show that I have purchased such and such medicine and I have misused those medicine, then no offense made out, Lordship.
If, may please come to my additional complaint, Lordship, paragraph 6 to 12, Lordship.
Supplementary complaint.
Yes, Lordship. Paragraph 6, 7, 8, 9, 10, and 11 and 12.
Yes.
Initially, notice under section 67 was issued to him. Thereafter, the agency came to know that he was arrested by Bijni police, Chapar police, in connection with Chapar PS case number 36720 under section 22B of NDPS Act.
Another case.
Yes, Lord. Thereafter, he was on arrest. He was arrested subsequently and brought to the Central Jail, Guwahati, Lord, where his statement was recorded. And thereafter,
What is the other case?
This is Chapar PS case number.
Where do you get? Oh, yes, yes.
It is there, Lords. My report also in paragraph 24, I have. In his statement, he has admitted that he is involved in this illicit drug business. Lord.
So those statements at this stage, but what he is stating is twofold.
Lordship.
First, there is no recovery from him.
Yes, that is
even
admitted.
from his constructive position.
Yes, that is there. Lordship, we are not on.
Number two, he had a license.
Lordship, having license is a different thing.
And he from whom he was to buy these goods also had a license.
No,
So
Lordship, not correct. It is not correct. Moghrewal didn't license. Lordship, he was admitted. Lordship required Lordship call for the final complaint. Or they have annexed, or I'll produce the entire record, Lordship.
But at least you are not disputing that he had a license.
Yes, Lordship, having license will not absolve him from the.
No, if you have a license, then if you are still making him an accused, then you should come up with a specific allegation that he has, in spite of having the license, he has either misused or sold to persons without a prescription or.
Lordship, in earlier case also, he was dealing with the Lordship paragraph that as per information of the officer in charge, Chapar police station, Aminul Islam, son of so-and-so, with 3 others had been arrested by Chapar police in connection with.
Paragraph?
I don't have extra copy of the supplement, but in my report, paragraph 24.
You don't have a copy of this.
Lordship supplement, but the report is with me. Lordship paragraph 24 of the report. Same statement is.
24.
Lordship.
Yes.
That as per information by the officer in charge, Chapar police station, Aminul Islam, son of so-and-so, with 3 others has been arrested by Chapar police station in connection with seizure of Codrex cup syrup, 11 bottles, Cepeno, Prox1 plus capsule 1,224 numbers and nitrogen tablets 1,100 numbers in Chapter PS case number 36722 under section 22B. The next paragraph, that further the prayer has been submitted before the Honorable Court of Session, Judge number 2 for recording the statement of Ainul Islam in judicial custody in connection with NDPS case number 60 of 2019. And the prayer was allowed. And paragraph 26, that on 12/10/2020, the statement of Ainul Islam was recorded at Central Jail, Guwahati. Ainul Islam accepted his involvement in the illegal business of codeine-based cough syrup. He accepted that he sold codeine-based cough syrup for consumption as narcotic drug. Ainul Islam accepted his involvement that he did not appear before the investigating officer despite receiving 3 notices because he was afraid that he may be arrested because he used to deal in the codeine-based syrup. So these things are there. Lordship, regarding that detention for long period, that this is not a ground as held by the Honorable Supreme Court in Mohit Agarwal's case. And in a recent judgment of 28 March 2023, while cancelling the bail granted by Allahabad High Court,
This Mugrave is granted bail or not?
no, it is not granted. Only Norezaman was granted. We prefer SLP that was dismissed on the ground of delay.
And the other one, Prohidul?
Prohidul Lordship, that is relating to state law.
So Tohidul is on bail.
Prohidul also granted bail.
That's not challenged.
Lordship, in on 28 March 2023, in the case of Ajay Kumar Singh, Union of India versus Yadunwar Singh, where Allahabad High Court granted bail, that was cancelled by the Honorable Supreme Court. In paragraph, it is on record that the respondent accused has been involved in similar crimes in the past, and the several cases are pending against him. I mean, Mohit Agarwal Lordship, regarding period of detention, that cannot be a ground in case of
Citation.
I'm giving the copy log. Yeah.
Yes.
And furthermore, Lordship, the trial is going on. 3 witnesses has been examined as per my land defense submission. And one is a recent judgment pronounced on 28th of March. Lordship, there is another judgment of Supreme Court they have not brought. In that case, Punjab and Haryana High Court granted bail to the person on the ground that Drugs and Cosmetic Act will be applicable. Honorable Supreme Court rejected the bail, holding that it is the prerogative of the prosecution to add the provisions of NDPS Act, spite of having their license.
Drug.
Just if regard, let's say, place, but they have not brought the judgment.
This matter has been assigned to this bench.
Lordship.
This matter is assigned to this bench.
Earlier it was rejected by your lordship.
Just I'm placing few facts, Lordship, what my learned friend has
We can
said.
have this on Monday then. But you should have got it today here. I think you have made your point clear.
No, just I'm clarifying what my learned friend has said because it is.
Can I have complete? Anything else? You bring that judgment also.
Yes, I'll.
Because what my learned friend is saying, Lordship, that is contrary to the record. Therefore, I'm just clarifying it. Page running
Which part?
to
Which part?
180, Lordship,
Which part of his statement?
that Moghrewali was not having valid license.
Yes, the lordship.
Yes, I'm enclosing the deposition of PW3. Your lordship will find, and from his drag license, your lordship will find that till when it was valid and cancellation order that your lordship may kindly ask them to produce. It was after 15/5/2019, and date of occurrence is 28/2/2019. After 3 months of the occurrence, his license was cancelled. That is not on, that is not from record, this submission.
Cancellation can be a subject matter, but at the time when the offense was LS, he had a license.
Just page 118 for a moment, your lordship may kindly say.
Valid license will not absolve. They have to.
Not at all, not at all, not at all.
Yes.
He is saying that the substance involved is also a substance which is medically prescribed. And he had the license.
No, lordship, that is.
Unless you make out a case that those have been misused or conditions have been, of the license have been.
Lordship, that is not the case of the department also. And in Nograb, lordship, I'll produce the record where it license was cancelled subsequently, lordship.
Subsequent, that's a different,
on the-
different
Lordship,
action.
no, lordship, why it was cancelled? That reason is also there. Because I argued in different cases, lordship. Because he misused the terms and condition of the license.
So what
That
is
was
the
the
offense here? Tell us.
Here,
If the
lordship,
offense, the substance involved can be medically prescribed. He is a license holder. Now, what is the offense?
no, lordship is, he's involved in illegal trade of narcotic drugs, cough syrups and other stuff. He may be having.
It has not been recovered from him either from constructively.
It is
That
not
is
our
gone.
case that it was recovered from the petitioner. We have also not stated it. He's.
How is what is the connection? The statement of the accused.
I'll produce all the accused, statement of the accused, lords. I'll produce all the statement of the accused, whether, and in one of the paragraph, lordship may please to see. Paragraph 21,
Okay, Monday we'll have. Monday.
lords. I'll produce the judgment.
Monday immediately after the motion, but. Heard the, yeah, learned counsel for the petitioner, also heard three SC Kyle. Learned any counsel, NCB. List for further consideration on Monday. Third.
Obliged.
Six. Yes, yes.
Your lordship, our names are not reflected. So today, we're not put to the brief. Your lordship can kindly post it the day as per your lordship's convenience.
He has produced a
Yes.
communication issued by you.
Yes, yes.
And there is some difficulty with the bank account. We can ease out the difficulty so that he is in a position to run the
What
business.
has happened, subject to your
So
lordship?
that you come with instruction, Monday we'll take it up.
Yes, your lordship. I'm grateful, your lordship.
List again on Monday by reflecting the names of
SCIOC.
SC, reflecting SCIOC in the cause list.
Yes,
Mr. Borava, come on Monday.
grateful. Your lordship.
Problem.
May I please, your lordship, the senior counsel, Mr. J. Roy, was taken for some medical emergency today.
Is it?
Yes, your lordship, he was taken some time ago in an ambulance from the court.
Oh.
Your lordship may kindly adjourn this matter for the day.
Okay, don't worry. It is submitted, that's free. J. Roy, senior counsel for respondent is unwell. Please, Dr. Ravi.
Much obliged.
You know, item number 30. Yes, contempt matter, who's there? Mr. Chamaria? None appears for the petitioner on call. None appears for the parties on call. Sarah, in the interest of justice, just after 2 weeks. Mr. Ratto,
Your lordship's pardon.
your names have been shown. Why don't you appear on 2 occasions? Who's on the other side?
Court, your lordship.
Who's on the other side?
Mr. P.K. Sharma and Mr. M. Wood. But your lordship, I required to file objection also, so some time may be granted. Your lordship.
Yes, yes.
Some time may be granted. Your lordship. I just,
But you should appear. Last occasion also you are not appearing. Names have been shown.
yes, your lordship, I beg your lordship's pardon, dear lord.
Huh?
I was in the different court.
48.
48.
We grant some time, but this is only a matter of arbitrator's
Arbitration.
appointment. What is the objection you have?
Regarding the case, your lordship, they were required to submit the security deposit of.
You
2%.
file a sort of it.
Yes, yes.
How much time?
Say, next week will be difficult, your lordship.
Your A Borpujari. All three A Borpujari learned counsel for the petitioner. Full stop. Para. The respondent is represented by Sri A.M. Datta, who prays for and is granted 3 weeks' time to file the affair in opposition. Full stop.
But date may be fixed.
Yes, tell us a date.
26th of April.
Yes, 26th, yes. List on 26th of April.
Must.
Item 31, my lord, I may be closed because the private respondent number 4, this period has expired. So petition may be posted after a month. I may be closed, my lord.
Close the IA?
I had 1473, 1744.
Itself has expired, my lord.
That is what?
Presently, there's no
Lease. Extraction.
extraction going on, my
The
lord.
lease period is already expired, your lordship.
Sri G.N. Sayola, the senior counsel, submits that the lease in question having been expired, comma, the I may not, the instant interrogatory application is not required to be proceeded any further. The said endorsement has been, the said submission has been endorsed by Sri R.R. Gogoi, standing counsel Forest Department, as well as MS.N. Upadhyay for
Response to 4, my lord.
Respondent number 4, full stop. I accordingly stands closed. And what about the
It
WPC?
may come out in May, my lord.
Huh?
In May, my lord.
Lease
WPC?
period is over, your
My lord,
lordship, so.
Lease period is itself is over.
Leave it over, but the other tax remaining.
In the WPC, right, you right? Heard Sri G.N. Sayola, senior counsel for the petitioner. Full stop. Also heard Sri R.R. Gogoi, standing counsel for his department, as well as MS.N. Upadhyay, counsel for respondent number 4, who both, full stop, both the learned counsel for the respondents have submitted that there is no cause of action surviving for adjudication as the lease period has expired. Full stop, para. The aforesaid submission will be taken up for consideration on the next date. Let's list after 4 weeks. None appears for the parties on call.
Your lordship, I am in 33 contempt petition, respondent number
None
1.
appears for the petitioner on call, whereas,
I am appearing item number 33, lordship.
yes, none appears for the petitioner on call, whereas MSK Fukan, learned counsel for respondent number 1, as well as MSM Devi for,
Respondent number
your name is not there.
lordship have is appeared.
Respondent number 3 are present. Full stop, para. In the interest of justice, list after 4 weeks.
Obliging.
In the interest of justice, in the interest of justice, matters stand adjourned to be listed. Yes, next. 3, 4.
There is an order from Lordship Court on 28 lordship. Service on restaurant 5 and 6 was not completed. I allowed to take trustee service lordship. So I
You
will
take
be allowed
trustee?
to take trusted lordship.
You take fresh service or dusty?
Trustee, sorry,
Dusty?
trustee lordship.
At 3-4, I am appearing only. Municipal court, I am.
You have already filed Wakalatama.
My lord, you have filed.
Heard Sri P. Sharma, current counsel for the petitioner, who submits that certain respondents, that respondent numbers 5 and 6 are yet to be served. Full stop. Sri B. Gogoi has appeared for the respondent numbers 3 and 4. Full stop. Para. Sri Sharma prays for a liberty to serve the respondent numbers 5 and 6 by Dusty. Full stop. Prayer is allowed. Full stop. The justice service is required to be routed to the registry of this court and the registry to indicate the next date fixed in the notice accompanying such justice service, that the next date be fixed on for which on 28th of April, prior to which date the petitioner is required to file an affidavit in proof of such justice service. High level. Yes, next. Contempt case.
Please, your lordship. Lordship has issued a contempt notice. If there is a case, my lord, of willful disobedience and blatant violation.
I am appealing for contempt number 3. Mr. Tikero is appealing for response number 1. My lord, there was some problem in confusion and all that. My lord, then some clarification were sought, clarification were given that work to be divided. My lord, yesterday the DGM law and my lord, the AGM came to me, my lord. They said they discussed. I said that no, whatever the court says, you kindly obey it and comply with the matter.
And contest the case rather.
And ultimately, my lord, the yesterday, my lord, that has been done, my lord. That the entire contract work of the FST New Guwahati will be given.
My lord, after passing of the interim order which I served on them for next 30 days, not a single allotment consignment was given to me. Contempt has already been committed. Now, from 13th, I was.
Put this on affidavit, we'll consider. Put this on affidavit.
We'll put on.
And my lord, one thing may be lordship may record. Worksheets may be produced. Worksheet with
No, see, Mr. Agarwal, senior counsel has conceded that there was some
My lord, I'm
misunderstanding.
not saying anything.
Not misunderstanding or not understanding or whatever, but good advice has been given to them.
This is
Yesterday, my lord, I said that you kindly
my lord,
comply.
your lordship's order is the most unambiguous and specific order I have ever seen. No question of my lord interpreting that order. The other man was allowed to work, my lord. Complete disregard, my lord, the majesty of the order of this court, my lord. Therefore, what I submit for 30 days, let them file an affidavit and the records pertaining to the
Okay,
worksheets.
Senior counsel. Also had Sri K. Agarwal, senior counsel for the response number.
3, my lord.
Sri P.K. Roy,
He is appealing, my lord.
senior counsel for response number 1.
1, my lord.
Who is 2?
2, my lord, your lord, he has not issued any notice. At least.
And Sri K. Agarwal and senior counsel for response number 3. Both the
Assisted by Mr. B.K. Singh.
by Sri B.K. Singh. Both the learned, both the response numbers 1 and 3 have submitted that though initially there was some confusion with regard to the order, subsequently, the order has been complied with in its entirety. Full stop. The said two respondents are directed to file affidavit in this regard.
Lordship, I record my submission also, that for 1 full month. Definitely, my lord, this is the way.
My lord, I don't deny, my lord. My lord, I am not, my lord, your lordship. I am very.
Record.
One full month after service of notice.
I'm not denying anything, my lord.
And there's some has been abided in its entirety. At this stage, Sri Barbara, the senior counsel submits that in spite of the interim order being unambiguous and clear, the same was disregarded and disobeyed for a period of almost a month. Full stop. The response was 1 and 3 are accordingly directed by the based on they
produce the worksheets. That will reveal. This is a matter of record, my lord. Day-to-day concern.
I am having it, my lord.
List on.
List, my lord, in the first week of May, my lord.
Lordship, give us a fortnight's time, my lord.
We'll have it on 3rd of May. 3rd of May.
My lord, last week of my lord, let us see the position. After Bihu, my lord, of course, after Bihu.
You are having the thing now.
I am yet to start.
I have given a copy to him, my lord.
On 28th.
28th of April.
28th of April.
It will be better, my lord. I am assisting the court. Affidavit is all right. For 1 month, they didn't comply willfully. Then, after service of notice of contempt, they have right.
Mr. Barbara, from you, we have learned that restraint is the best exercise of powers.
But leniency at times, my lord, causes problem for the client.
It's restraint which call for restraint. If you exercise,
It is high time, my lord.
Lord, we'll seek apology, my lord, unconditional apology.
For
my
what?
lord.
For one
Not-
month?
If not that, my lord.
okay, we will exercise if it's actually needed.
I submit that contempt is already complete.
Okay,
For
let's,
1 month.
let us see the affidavit, their conduct of the affidavit.
Lordship.
We may have a personal interaction with the officer.
Officer, definitely. This is a matter, my lord, serious matter. And a very specific order from your lordship.
Okay, next. Mr. Hussain, what is this?
My lord, there is a case, my lord,
IFR?
I for interim order, my lord, to allow the petitioner to withdraw his salary amount from his account, my lord, by keeping an amount of rupees 4,35,000.
That is the amount in question.
Amount in question, my lord.
Lordship,
You are the
that-
bank, Mr.
I am for the bank.
Oh.
The petition cannot be allowed. Because this is a case of fraud. And the petitioner's account is involved in fraud. From the record, it will be seen that he himself was involved. And he has suppressed
No, what-
all those facts.
No, no,
In-
after what he's saying, that leave aside the amount which is involved, 4 lakhs or whatever. Thereafter, he should be allowed to withdraw his salary from the account. But it's because that is-
My lord, criminal proceeding is still continuing. Investigation is continuing.
No, by this order,
Investigation is
by
continuing.
this order, we are not saying for a moment that he is absolved of his criminal liability. Whatever is on. But his livelihood. If you want to object, file your objection, you file your
Then
objection.
I will
Not
file
yet,
objection.
You file your objection, but I don't think this,
My lord, since November 2020, my lord. Cannot
Because he has
withdraw
filed the
our
date of
salary amount
mandamus.
from the account, my lord.
Arts P. M. Hussain, Learned Counsel for the applicant petitioner. Full stop. Para. 3. P.
Paper.
Sorry, A. Parvij. Learned Counsel for the SBI. This submits that he would file objection to the IA as the account in question, as all the fraudulent activities have is in connection with the account involved in this matter. Full stop. Para. Let such objection be filed within a period of 3 weeks.
4 weeks, because I have to take instruction from UP, Uttar Pradesh.
For a moment, my
Okay,
lord,
4
kindly peruse the paragraph 9 of the affidavit.
Let him file, let him file, let him file. We'll pass
Because,
orders.
from November 2020, my lord. The
Now
petitioner.
this application has been filed recently. We have to give him a chance. We'll fix a date.
Short date may be given, my lord.
So I have to take instruction from Mirror, Uttar Pradesh.
In this regard.
Mirror instructions are by email and telephone.
My lord, in this
You
regard.
don't need to go to Mirror. You need to go to Mirror.
4 weeks. After
we'll-
Bihu.
We'll have it, we'll have it after, we'll have it on 26th,
Time maybe fixed.
26th April.
26th.
In this regard, my lord. Already
next.
affidavit filed, my lord.
We'll hear you. Let the objection come. 26th, next.
26th April, my lord.
26th April.
Your lordship, instead, the matter may be taken for admission because pleading has been exchanged.
You file your objection. If
No,
you are,
date
if there is delay, we can at least consider his prayer
Yes,
for his salary. Yes, next. Thirty-eight.
Please, your lordship. I have for correction of order. My lord, this is a typographical error in order dated 27/1/2023.
Page.
Page 4.
No, in the order, which paragraph?
Oh, no.
In the petition, well,
The petition.
petition.
Oh, in the petition.
Petition.
Yes, what have you stated? No, I for what?
I have for
Correction in the order, you are seeking correction in the order.
Yes, my lord.
You are seeking correction in the order of 27, isn't it?
Yes, yes.
We are in the order of 27. Which part you want to be corrected?
My lord,
the contractual due amount, actual amount is 2 crore 52 lakhs,
Not 25 lakhs.
not 2 crore 25 lakhs. Wrongly typed,
Where in the order,
yes.
where is the statement? Where is the statement 2 crore 52 lakhs? Indeed,
Hello, page number 6, my lord.
so you have written 2 crore 25 lakhs in paragraph 3.
Yes, my lord. This is my lord excluding GST, my lord. Really,
We do not know.
Not
You have written in bold 2 crore 25 lakhs.
yes, my lord.
You come to your repetition, paragraph 3.
Yes, my lord.
Let us see your prayer. Prayer you written 252. Your name?
Kedas,
Hmm?
on the behalf of Ambiswas.
Your SK Das. Part 3 SK Das Learned Counsel appearing on instruction of 3 Ambiswas. Madam, anything from her?
Lord, we have received the instruction, they have already, the due amount has been paid, my lord.
That has been paid to. Okay, it's paid. What else remains? 21.3. Just recently and 252, not 25.
Lord, actual amount is, actual contractual due amount is 2 crore 52 lakh.
That has already been paid to you on 21.3. And who has filed this application for correction in the order dated 27/1/2023, wherein the amount in question has been written as 2 crore 25 lakhs, which should be rupees 2 crore 52 lakhs. Sarah, on the other hand, comma, MS Bora, A Bora, and its standing counsel, NHM submits that irrespective of the paid issue, comma, as per written instructions received by her dated 22/3/2023, comma, the amount in question, namely 2 crore 52 lakhs, has already been paid to the petitioner on 21/3/2023. Full stop. In that view of the matter, comma, both the IAs and the petitioner as such are not required, I do not call for any further adjudication. Full stop. The IA as well as the writ petition accordingly stands closed. A copy of the communication dated 22/3/2023 is made part of the records. You inform your clients. Maybe it's a recent development, they could not tell you. It will do it at Lihivo, no? Close করলো একটু। এটি এগুলো আজিজ ক্লোজ করলো। ওখানে নোটিশ অফ মোশন আছে। এখানে বোধ দি বলে করো না।
Might be lost.
Yes, Mr. Chaudhary.
Only for a clarification of this matter, this petition was filed. Your lordship, yes. Your lordship kindly see first order by the page 21 of this, by the page 21. The private market, there is a stay order, my lord, in private market, cattle as well as the other goods market. So Panchayat has issued NIT, so that we challenge, and that was stayed, your page 22, your lordship.
Yes.
Now they have come for clarification of this order, which your lordship will find page 23 and page 27, your lordship will name. They wanted to say, my lord, yes, as far as home talukdar, private market, there is no restriction, but it is subject to other law. In the meantime, cattle act came into being. So they, my lord, this order, you will kindly say last part of this order, my last part.
Page
29. Page 29.
Yes, please.
That interim order was clarified. Accordingly, your lordship will find. Accordingly, the interim order dated 7/2/20 in WC number so would also have to be understood that the operation of the cattle market by the writ petitioners would be subject to requirements of the Assam Cattle Preservation Act 2021. Fine. Then your next page, you'll also write in terms of this order, ADC, first an order, my 19th September, last part. It referring to this order, my lord. As such, until the Haldabi Anchalik market is registered, licensed, recognized under above mentioned section of so and so and rules of Assam so and so, the operation of so and so cattle market will remain suspended with immediate effect. Then I approached the deputy commissioner. And in the meantime, I came to know which I could not bring it to record. In the meantime, already registration has given by the by deputy commissioner. In the meantime, we got it on 17/T/23. It was already issued, man. So that already that embargo already come. Now, only close by I could not bring it to the record, but I have the copy, my lord. My learned friend also makes it fine.
You place it on record, it'll be better, I think. Why would you short affidavit?
So in that case, I can do about this.
In the meantime, we'll also file our objection. I'm appealing for the respondent number 10.
As Sri H.R. Chaudhary, London City Council submits that as per information received very recently on 17/3/2023, a no objection certificate has been given
by the deputy commissioner.
By the deputy commissioner Gwalpara. Full stop. The aforesaid fact may be brought on record along with the relevant document by way of an additional affidavit. Full stop. Sri
A.J. Hazarika.
A.J. Hazarika, London Council for the
Respondent number 10.
Who are you?
At whose instance?
Okay, they're private
Settle,
respondent.
I'm,
Private
settle, yeah,
respondent.
settle market.
Private respondent.
Yeah,
private
On
respondent.
place for some time to file his objection. Full stop. Sarah, let this matter be listed after 3 weeks.
Well, a date may be given, madam, because we are
Let the matter be listed on
immediately of Bihu, madam, because I will file within 2 days, madam.
26th.
Obliged to.
I'm appealing for the Panchayat department.
Sri S. Dr. London Standing Council. PNRD department is present.
I'm for the
For revenue, state.
No, state.
For and J. Hendrik for this. Yes, next.
I'm nice.
I know.
20.
Mr. Suresh Kumar Rai. What is this, Mr. Singh?
My lord, I'm a contractor by professions. I work in different departments.
My lord, yes, my lord, here, my lord, they filed a my lord, yes, actually in this case, my lord, they were, my lord, suspended in the GEM portal. And all the contracts diverted by the GEM only. On 22nd of February, the interim order has been passed. I have verbally communicated to the authority. But my lord, thing is that, my lord, practically the order is not uploaded in the my lord, on till my lord, 28th of February. And the authority, my lord, without knowing the my lord, actual fact, my lord, on 24th, the army has passed the order debarring the petitioner for participating in the army crop zone. Subsequently, as per the interim order, my senior will clarify, my lord, he has been retained in the GEM as per the interim order. He is in GEM, but in the army area, he has been debarred from participating in any tender. Only in the crop zone. That is the order in challenge in the IA. Practical, yes, after the interim order, but interim order is regarding the suspension in the GEM portal. And one point is that, on that, yes, on that, the petitioner's consent submission is that only filing a FIR, it doesn't mean that case has been proved. But subsequently, though I have filed the affidavit, but subsequently.
But his name is presently there in the portal.
No, yes.
Retained.
Retained in the GEM.
After this interim order, but thereafter, after 2 days, my lord, the army has debarred me permanently.
Because in the case, it is already suspended. I got the
last action, my lord, by the army authority. And all the army authorities who have done this, my lord.
If you have retained his name in the GEM portal and yet debarred him from participating in
the army crop zone area.
Now, what GEM portal is for which area?
No, my lord, any tender for central government, he has to go through GEM portal. His
the blacklisting was by whom? Army only.
Only army.
The interference by this court is only regarding the action taken by the army.
No,
J-
my lord, no,
J-
no.
G-
That day, my lord, his submission is that,
Mr.
my lord.
Parashar, JM is only a nodal agency
My lord,
to
yes,
conduct the
Yes.
tender process.
yes,
It is
yes,
outsourced,
my lord.
so that there is no there is a 100% transparency.
No, my lord,
JM is not bothered which matter he is.
no, my lord.
Now, if you are still
his-
debarring,
His submission is that, my lord, he has contracts works in other department also. And if it is suspended, he will be, my lord, he will be difficult during this mass ending, my lord. And it is after the interim order uploaded, my lord, it is written in the JM,
Mr. Parashar,
my lord.
that is not the lookout of the court. We have passed an interim order on the basis that before you had blacklisted him, you have not given him any opportunity, which you cannot do.
Personally, my lord, actually for JM, my lord, it was given, my lord. I have,
No, that is a submission on merits.
my lord, yes,
You can very well say that his contention is not correct,
my lord.
but we have come to a prima facie finding, given an interim order. Thereafter, if you debar him from the works which you intend to float,
My lord.
that will amount to violation.
No, my lord, practically, my lord, basically, my lord, yes, army authority also.
No, you cannot debar him. If you are debarring him, then we'll have a suo motu contempt proceeding initiated against you.
My lord, practically.
You give the names of the
No, my lord,
officers.
I have,
Instead of justifying, they would have withdrawn.
yes, my lord, I have communicated.
We withdraw
privately,
this gratuity a week's time, withdraw this. And
That is what I am trying
you
to say.
treat him at party or and in the meantime, you're at liberty to contest the
Already
case.
he's in JAM, my lord. JAM already, my lord, retained in JAM, my lord. That is,
But what about this order of 24/2/2023, by which you have debarred him from consideration?
in the, my lord, yes, crop zone area, my lord.
You contest the case,
No,
you challenge the
definitely.
interim order.
Definitely, my lord, and also, my lord.
If an interim order has been passed,
My lord.
either you have to comply or you have to challenge that order.
No, no, my
You
lord,
cannot say that I'm not
obviously.
going to comply with the order.
No, obviously, my lord.
If you are not, if you say the interim order is not proper, division bench
yes.
is there, you can still come up before this court saying that should be vacated because
My
see,
practically, that
this
person was
interim
also, my lord.
order are passed on a prima facie consideration. There is no full length consideration from your part. You may have a different story
The
altogether.
observation is there, my lord. Kindly see. the
You come up with
authority
your
that-
case, we'll consider. Maybe he doesn't have a case at all. Maybe his projection is entirely incorrect or false. But on the date when the case was presented before us, we came to a prima facie inspection that a case was made out. So to balance the equities, we had passed an order.
My lord.
That order needs to be complied with.
And it was
If-
done in their
If
presence,
you,
my
if
lord.
you, if you are taking the responsibility of advising your client, we'll
No,
have
my
it
lord,
after a
practically
week.
not. Well, I'm sorry, my lord, but I beg apology for not part of.
No,
the-
no, if you can advise your client to take same decision, okay. Otherwise, you'll have their person appeal.
No, my lord, we are going to find, my lord.
Heard pre-escaping learned counsel for the petitioner, who by applicant petitioner, who by means of this application has brought to the notice of this court that in spite of the interim order dated 22/2/2023 passed in the accompanying writ petition WPC 960/2023, an order has been passed on 24/2/2023, whereby the petitioner has been debarred from any works that may arise in the core.
Crop zone area, my lord. My lord, page 13 of the IA, my lord. Page 12 is the order, my lord. Last paragraph, my lord. Contractual activity in the crop zone area, my
It's not courts, it's core.
lord.
You have to pronounce core. National Cadet Corps, not
Right.
corps.
Right.
In the core zone area, full stop. Sri Singh, the Learned Senior Counsel submits that the state order, apart from being indirect, apart from being illegal, apart from being unreasonable, is in direct conflict with the direction of this court. Full stop. Sri Parashar, K.K. Parashar, learned CGC, however, submits that due to improper communication of the order dated 22/2/2023, the state order was issued, which however has been rectified by bringing bringing the name of the petitioner back in the portal of the GEM. You are for GEM?
I'm for JAM, my lord.
The aforementioned submission is also endorsed by Sri B. Chakraborty, learned counsel, appearing for the GEM portal. Full stop. Para. Sri Singh, the learned senior counsel for the applicant, however, response is, however, submits that by restoring the name of the petitioner in the GEM portal would not be a compliance of the order and the intent of this court while passing the order dated 22/2/2023 as by mere restoration, comma, the prejudice caused to the petitioner would still be there if the order dated 24/2/2023 is not interfered with. Full stop. Para. Prior comma, the aforesaid order does not appear to be in consonance with the order dated 22/2/2023 passed by this court, and rather appears to be in violation of the said direction. Full stop. At this stage, Sri Parashar submits that he would take appropriate instructions from his client regarding the steps taken for complete compliance of the order in question. Full stop. List this matter for further consideration on 19th of April.
My lord.
Obliged.
Mr. Bhagavati, we have intruded upon your interview today. But sir, yes, what is it?
May I please, Sir Lordship? My Lordship, 15/3/2023, order passing 2023.
Yes.
WPC. In the certified copy, there is typographical error.
Error. What is the error?
In page 20,
20.
yes.
Yes.
WPC, there is WPC 1743/2022 instead of 2743/2020.
It should be 27.
Lordship.
Your name?
P. Talukdar.
MSP Talukdar, learned counsel for the applicant petitioner submits.
Lordship, the applicant pressed for extension time limit for 15 days to file the representation before the circle.
Okay. Submits that in the order dated 15/3/2023 passed in the accompanying in the connected writ petition 1339/2023, comma, there is a typographical error in recording the number of an earlier writ petition which was disposed of. Full stop. He submits that instead of WPC 2743/2022, comma, the number has been written as WPC 1743/2020. Full stop. He further submits that due to the aforesaid inadvertent error, comma, the representation which was directed to be filed within the stipulated time of 15 days could not be done. Full stop. Also heard Sri A. Bhattacharjee, learned Senior Counsel Revenue Department, as well as Sri J. Hendrick, learned State Counsel. Full stop. Para. After hearing the learned counsel for the parties, comma, the instant I stands allowed by correcting the WPC number from 1743/2022 to WPC 2743/2020. Consequently, the direction granting liberty to the petitioner to file representation, which was for a period of 15 days from the date of the order, that is 15/3/2023, stands extended by another 15 days from today. Full stop. For all practical purposes, comma, the order passed today in this I may be regarded as a part of the order dated 15/3/2023, first in WPC 1339/2020.
Right.
I understand this both of. Here for the bank.
Yes, Your Lordship, for 2 and 3, Central Bank of India.
Today we will not say they are not appearing, because it's not the time exact, but two non-appears for the petitioner on call, whereas we have Sharma, Colonel Standing Counsel, Colonel's Counsel is appeared for the response numbers
2 and 3.
2 and 3 for the, in the interest of justice,
Pending counsel.
they are standing us.
And Your Lordship, a copy may be directed to be given.
And no one is there.
Order may be.
To whom? Order has to be an effective order. In the interest of justice, list after 2 weeks. So, in the matter stage adjourned. We will list out. Yes, last one.
Please, Your Lordship. My Lord, in this matter, my Lord, I am for respondent number, private respondent, my Lord. The matter may not be taken today, my Lord. My Lord, there is some.
This is for what? Stay vacating.
No, Lordship. Come out in the stay column, not stay vacating it.
Are you for what? Oh, it's for stay. You're praying for stay. But status quo is there?
Status quo is there, my Lord.
It may be continued.
It may be
Uh,
continued, my Lord.
Honorable A. Manaf, learned counsel for the private respondent, prays for prays for an adjournment. Also heard Sri F.Z. Mazumdar, learned counsel for the writ petitioner, who submits that in that case, the order of status quo may be extended. Full stop para. Matter is adjourned by 3 weeks.
My Lord, after vacation, my Lord, BU vacation.
The matter is adjourned by 4 weeks. Interim order passed earlier to stands extended till the next date of list. Mr. Prasad, anything?
It is item on. Account. Would like to submit this.
Okay.
Okay, one simple request, Lord. In item number, I'm sorry, Lord. I'm sorry. Item number 49, the other side was requesting me to extend their interim. It's a GMC method, Lord. My instruction is awaited.
49.
Yes, Lord. The demolition order was issued. On last day, Your Lordship granted an interim order.
I think we have passed some orders.
49.
Yes. 49 was taken up. Admission matter.
Your Lordship, I was.
Admission matter taken up. Did, madam was there, did us.
Lordship, I am appearing for GMC, Lord. My instruction is awaited, Lord.
The past order, Ranjit Kumar Bose.
Yes, Lordship.
The past order, you have to check.
Lordship. I'm sorry, Lord.